Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
You may be seated. Mr. Birch.
Thank you, Your Honors. My name is Chan Cresswell, and I, along with my co-counsel Emma Rose Bagwell, represent Mr. Shaw, the petitioner in today's case. This case was last before this court in 2023 when Mr. Shaw alleged that prison officials violated his procedural due process and his First Amendment rights by falsely accusing him of an offense, denying him access to potentially exonerating video evidence at his hearing, convicting him and using that conviction to raise his security level and transfer him to a maximum security facility. This court reversed the district court on both claims, holding that there was a cognizable liberty interest in his transfer to a maximum security facility, and that the official's failure to produce the video was, quote, profoundly powerful circumstantial evidence that perhaps they did retaliate, on page 123 of the record. On remand, after discovery, the district court again granted summary judgment and dismissed both claims, this time without addressing Mr. Shaw's motion for spoliation sanctions on the destroyed video evidence. This court should reverse the district court for two reasons. One, the district court abused its discretion under Wall v. Rasnick and Federal Civil Rule of Procedure 72A by failing to rule on Mr. Shaw's sanctions motion. And two, in the light most favorable to the non-moving party, a reasonable jury could rule in favor of Mr. Shaw's due process and First Amendment retaliation claims. Turning to the spoliation sanctions motion, Federal Rule of Civil Procedure 72A lays out a process in which magistrate court judges have the appropriate hearings and decide the non-dispositive pretrial matters assigned to them. When appropriate, they issue written rulings, and then there can be objections. The rule requires that district court judges consider those objections and modify or set aside if the underlying ruling is clearly erroneous or contrary to law. Here, that order of operations was interrupted by the district court's decision to grant summary judgment. On January 19th, there was a motions hearing about this spoliation sanctions motion from the magistrate court judge. He ordered supplemental briefing 5 days later. Before getting to that point, the district court judge put a text-only docket entry saying that he was going to grant summary judgment before that spoliation motion briefing was due. And in doing so, it interrupted the flow. But in his opinion, the district court judge never addressed Mr. Shaw's spoliation sanctions motion.
What relief are you seeking on your motion for sanctions?
Your Honor, Mr. Shaw requested two adverse inferences. One, that the video would show that he did not commit the underlying offense, and two, that defendant Adams had seen the video and knew that it showed that Mr. Shaw didn't commit the offense. And the reason why the spoliation sanctions motion is so important is because it goes to Mr. Shaw's claims here today, particularly that First Amendment retaliation claim. Mr. Shaw needs to show knowledge.
But what relief do you want us to give?
Your Honor, we'd like it to be reversed back, sent back, remanded back down to the district court for a ruling on the spoliation sanctions motion. It is important for what can be read in the light most favorable to Mr. Shaw. And this abuse, this not ruling.
So you're asking for a remand for reconsideration. You're not asking us to send it back for, as a matter of law, for some relief to be granted.
No, Your Honor. We're asking for it to be remanded back for reconsideration on this spoliation sanctions motion and for reversal on the procedural due process and the First Amendment retaliation claims.
Okay.
Yes, Your Honor.
Shouldn't the constitutional claims be reconsidered after the spoliation motion is ruled upon, rather than simply reversing the? It seems that what you're arguing is that the two matters were taken out of order, and that the spoliation motion should have been considered and ruled upon first, so that the district court could consider those sanctions together with the merits of the summary judgment motions. Is that right?
That's right, Your Honor.
And so are you asking us then simply to vacate the summary judgment motion and ask the district court to rule on it after the decision on the spoliation motion?
Yes, Your Honor, that would be one way to handle it. But the spoliation motion is important for those claims. Here, the real abuse is in the district court not making a ruling and not mentioning the spoliation motion at all. In Wall versus Rasnick, Judge Wynn said that when there is no magistrate court ruling, you could look to what the district court said. But here, the district court said nothing. There was no magistrate court ruling for Mr. Shaw to object to, and then the district court didn't mention it at all. And so that leaves us in a place like this court ruled in Bailey versus Christian Broadcasting Network, where it said that the factual record was not able to be reviewed. It wasn't ready for judicial review because there was no way for this court to look at the spoliation decision. There's no decision here, and Mr. Shaw wasn't even able to make objections to whatever the magistrate court judge would have decided. And that's an abuse of discretion. It should have been ruled on. And there shouldn't have been a grant of summary judgment before that was ruled on. And in that case, it should have mentioned the spoliations motion. It could have been an implicit denial, but it should have mentioned why it was an implicit denial.
Although even if your spoliation request for inferences had been granted, as I read the district court's opinion, there still wouldn't have been a claim because there would be no liberty interest on the basis of the factual finding that there was no difference really between the conditions at the prison where he had been housed and the Red Onion facility.
That is what the district court said, Your Honor, but the record does not bear that out. You can look at page 925 of the record, and that's where the VDOC themselves are making a differentiation between Sussex State Prison, where Mr. Shaw was held, and Red Onion State Prison, where he was transferred. There, the VDOC calls Red Onion State Prison a maximum security prison. Mr. Shaw's own experiences, he said that being at Red Onion State Prison meant that all inmate movement was done at gunpoint. That there was more gang control, that it resulted in more lockdowns and the inability to contact his counsel or his family. That's on page 451 of the record. Even the defendants recognized, Defendant Leach, Defendant Foreman, and Defendant LeBeau on pages 303, 272, and 289 of the record agreed that there was a difference between Red Onion State Prison and Sussex State Prison. Defendant Leach said that those were the only two facilities that were level 5 and above. The state's classification system requiring that Red Onion State Prison be for level 5 security prisoners and above shows a differentiation between Red Onion State Prison and Sussex State Prison.
And that ruling then would be unaffected by any adverse inference, even if the spoliation motion had been ruled upon.
That's right, Your Honor. The district court was mistaken on this regardless. The spoliation motion really goes to the First Amendment retaliation claim and the knowledge that Mr. Shaw needs to show when we're coming to First Amendment retaliation. On this procedural due process, this court said last time that Wilkinson showed that incarceration in a maximum security prison was so atypical and significant that it gives rise to a liberty interest against any plausible baseline. That's on page 115 of the record. And it also said that maximum security facilities were those like Red Onion on page 115 of the record, those that have highly restrictive conditions. This inability to differentiate is just not bared out by the record. The defendants say that Mr. Shaw needs to point to some specific language in order for there to be a state-created liberty interest. And that is true that under Prieto versus Clark, there needs to be some state law or policy, but it's not as formalistic an inquiry as the defendants make it out to be. In Cuma, this court said that it didn't have any problem finding that there was a state policy and a created liberty interest because there was annual review. After Wilkinson, this court said, or the Supreme Court said that the touchstone of the inquiry is not this formalistic language drawing, but rather the nature of the conditions themselves. And here, Mr. Shaw does have a state-created policy interest. You can look to, at first, Your Honors, it's just the policy to not be convicted for no good reason. The fact that there is a formal process that is created by which these offenses are heard out. But further, Your Honors, you can look to page 313 of the record. Virginia DOC Operating Policy 831 says a formal due process hearing is required when you face the possibility of a security increase outside of the annual review cycle. Or page 929 says that security...
To what extent do you think the district court did not faithfully follow the first decision? I mean, the first decision we had, and you seem to say that you should only send it back for reconsideration, but a question of whether we should reverse on the merits, because it seems we found that there was a liberty interest in not being transferred to Red Onion. Does that have no place in your argument?
No, Your Honor, I would agree with you, Judge Wynn, that the district court did not follow what this court had said last time, neither here on the procedural due process or on the First Amendment retaliation claim. And to those matters, I think it would be appropriate for this court to reverse on the merits. The district court did not follow those and instead found new things to try and differentiate, that like this non-differentiation factor, which isn't borne out by the record, to try and hinge its ruling on. Your Honor, looking at the First Amendment retaliation claim, it's a very similar story. Last time, all parties agreed that Mr. Shaw had engaged in protected activity and that there was an adverse action taken. And now the district court has changed its tune. On page 120 of the record, this court said last time that the district court found and the prison officials do not dispute on appeal that Mr. Shaw engaged in protected activity. And then it later said that the district court likewise found and the prison officials do not dispute that prison officials took an adverse action against Mr. Shaw.
So, I mean, you have I think a really good argument, but at the end of the day, what the district court didn't deal with was qualified immunity. And we can go around in circles about that, maybe send it back, let them do so, but it isn't pretty clear that this action happened before our case, before the Lanier case, and it was not clearly established at the time that this happened, and very likely you're not going to prevail on qualified immunity, it seems. Do you agree or disagree?
I do not agree, Your Honor. I would say that Lanier was recognizing something that was already known, that this video evidence was a part of the documentary evidence that prison inmates may be entitled to under Wolf. You could look to Witt versus West Virginia State Police Troop.
So to get there, we would have to find a case like Lanier that was either on point in this circuit or the Supreme Court. There is no such thing, other than to say inherently this is something everybody knows, but I don't know if it rises to that level. I'm just simply, you know, it seems like we can dance around this, and it maybe ultimately because the Supreme Court, because the district court didn't deal with it, we just sent it back. But at the end of the day, that is the elephant in the room in this case, whether you prevail on the merits or not, and whether we see it's a liberty interest, whether it was invoked, but the question is going to come up, are they entitled to qualified immunity? And that's a very difficult question for you. And I'm not sure you need to argue it now, but it's the elephant in the room. I mean, in terms of your client. I mean, we can go back and forth all day long, but that's what's here.
Well, Your Honor, I would just point this court toward Booker versus South Carolina, in which Justice Gregory noted that a consensus of persuasive authority could show that the qualified immunity does not stand here, and that the real question is whether or not the defendants were on notice. Here, the defendants were on notice. By their own words, the defendants were on notice that Mr. Shaw had a right to this video hearing.
Is this record sufficient for us to make that determination here? Is the evidence? Sometimes we do address issues that aren't presented to the district court because the record is so replete with evidence that we just proceed with it. We've done that. And so is that something you're asking, or is it just something you...
Not necessarily, Your Honor. The district court did not find that there was qualified immunity. They did not rule on qualified immunity. And this court said last time that it didn't want to be a court of first review on the question of qualified immunity. But I will say, Your Honor, that on page 83 of the record, Defendant Murphy says, in response to an informal complaint, that the hearings department will advise and resolve. And on page 81 of the record, Defendant Foreman says that he won't review the rapid eye evidence, but that Mr. Shaw could request the hearings officer to do so if he'd like. That's in the record. These defendants were on notice. And lastly, Your Honor, the Third Circuit, the Seventh Circuit, and the Tenth Circuit noted that there were cases saying this video evidence was documentary evidence in 2011, 2003, and 2007. And for those reasons, this court should reverse. Thank you.
Thank you. Mr. Breckenridge?
Good morning, and may it please the court. Tillman Breckenridge for the Commonwealth of Virginia. At page 182 of the JA, Mr. Shaw describes himself as a gunner. A gunner is someone who masturbates in front of female officers at the prison. To use his own words, I am a gunner. I have been forced to reside in 4A pod. However, I will not be here.
What does that have to do with compelling? He says there's a video. Seems like to me this case is all about this video. And he says, I mean, certainly what you're saying is entitled to some understanding. If you have a factual account, he has a factual account. He says there's a video of it. And then he kept asking for this video, but he couldn't get it. And then ultimately it was destroyed. And after it's destroyed, he then still wants it, and he discovered it's been destroyed. After this court makes a decision, said he's entitled to have this video, but the district court doesn't address spoliation. I mean, your facts, we'll go ahead and deal with that, but I mean, this is not a jury. We need to deal with the evidence. What's it got to do with this video that would have either, presumably could have shown either he was doing it or not doing it?
Well, Judge Wynn, it has everything to do with these facts. The fact of him being an admitted gunner, the fact of him having had 4 confirmed charges before he was transferred.
You don't need a video to say he's guilty. You can just say he's guilty because it's past conduct.
Well, no, Your Honor.
And if there's a video, we don't need to look at that because we already know what that video says. Is that what you're saying?
No, not at all, Your Honor.
I'm trying to understand it.
Well, yeah, what I'm trying to get at.
But I'm not giving you a chance to explain it, so go
That's
ahead
fair,
and explain it to me. Because it's going to be intriguing to hear how you explain that one. At least to me, but maybe not.
Well, what I'm trying to explain,
And
Your Honor.
just to clarify, the 4 prior convictions were all vacated, isn't that right?
No, Your Honor, they were not.
They were dismissed, they were reversed, they were
Nope,
erased?
No, not at all. They are part of his disciplinary record. There were some that were vacated, including this one, and that's what I'm getting at, Your Honor, is that the video in the end doesn't matter. Like we can concede for the purposes of this appeal that the video would have shown that this particular instance was a case of mistaken identity, and it wouldn't change anything. Because what ended up happening was this caused them to look at his record, Mr. Shaw's record, where just months before all of this, he admitted to being a gunner who could not control himself. And then they look at his record and see that he has 4 prior instances of this. And then they compare that to their policy of moving gunners to prisons out west, also maximum security prisons. One thing to make sure that is ultimately clear in this is that Sussex is a maximum security prison as well. They're both level 5 prisons, and the comparison is not accurate to say that Red Onion is somehow worse than Sussex, and that's another issue to get to a little later in the discussion.
So why is that not a factual issue?
Why is what not a factual
As to
issue?
why he was moved there?
Well, it's not a factual issue because there's no facts on the other side of it, Your Honor. I mean,
You're saying all the facts that support this video, you've overturned that. In other words, he's gotten his remedy for that.
right.
And what he went there for is something separate from this.
Well,
So
I wouldn't.
this video has nothing to do with anything. Is that
Well,
what you're
no, I
saying?
wouldn't say it's separate, Your Honor. I would say it's redundant. And so that charge definitely spurred the review of his record and definitely spurred him being sent to Red Onion. There is no dispute about that.
And doesn't the paperwork for the transfer specifically say that it was based on this conviction?
It does say it was based on this conviction,
And
but
this conviction, had he had access to the video and had it shown what he says it would show, then there wouldn't have been a conviction.
There wouldn't have been a conviction, but there would have still been the policy that gunners are transferred to Red Onion. So there still would have been a review of his record that.
And are gunners that have no convictions transferred to Red Onion, or do they have to have a conviction for gunner? Is it based simply on a statement, or is it always based on a conviction?
It's always based on a conviction, but he had 4.
And what your statement is they went back to look and found these others after the conviction
Well,
in 20.
yeah, that's just necessarily part of the record. So at page JA 1089, as the district court recognized based on the disciplinary record, and I'm forgetting the JA number, but it was Exhibit 83-1. It was Exhibit 1 to the motion for summary judgment, which is at Pacer 83-1.
Mr. Breckenridge, how long has the Commonwealth known that the video is irrelevant?
The position of the officers at the time was that the video was irrelevant because they believed that it wouldn't show anything because the video doesn't show faces.
No. I'm saying irrelevant. You just told us that it's irrelevant, no matter what it shows. I'm saying, when did the Commonwealth know that it didn't make any difference because he was being transferred because he's an admitted gunner? And he admitted he was a gunner before this incident, right?
Yes, Your Honor.
So how long ago, so he would have been on his way to Red Onion anyway, is what you're telling us.
Yeah, I think that's a fair reading of the record, Your Honor.
But why didn't you didn't tell the court this?
I'm sorry?
Why didn't you inform the court? We were in litigation, weren't we?
Yes, Your Honor.
And was hide and seek?
Well, no, Your Honor, I can't speak for
Yes,
what.
no, you have to speak for the Commonwealth because they're the only person here for the Commonwealth today. So you're telling me this is the second time here, now we know that, this was unnecessary. He was a gunner. He already had the 4 points on him, and therefore he's on his way. So that's why we don't have to worry about the video.
Well, Your Honor, that kind of gets to the whole issue of whether or not the findings of the first decision are binding on the district court. The record was not developed for the first time around. So the first time around, we didn't have all of this in the record. The first time around, the motion was granted on a motion to dismiss / summary judgment before discovery. So his disciplinary record and all of that stuff wasn't in the record. It then got put in the record after remand because we went to discovery as the court required. And then now that the information is in the record reflects all of the disciplinary history and it reflects his complaint.
I thought you just told us that it was this charge that made you say, let's go back and look at his record. He has 4, so it doesn't matter. You had the record. We didn't need discovery from the court. You had his record there. You're the repository of his record. I mean the Commonwealth in terms of the Bureau of Prison or Corrections. So it looks like this is it retaliation because I don't know. You should have said that a long time ago, shouldn't you?
Your Honor, if I could get in my time machine and tell prior lawyers to say it, I probably would, but at the same time, the record was just not, there was no record, and so the court was going off based off of the allegations of the complaint and the prior.
It seems like you're doing a whole lot of moving pieces here. You come here one time and say it's clear this was the offense that was done. He went through it, he asked for the video, and you put this man through all of these things trying to go to calling Richmond saying, what's going on? Why can't I have this? And then all along you knew, well, we've already checked your record. You're on your way to Red Onion anyway. And therefore, we'll drop these charges and not waste court time or anybody else's time and send you to Red Onion. So now we know that I don't know, it's kind of difficult to understand that, Mr. Breckenridge.
In either event, Judge Gregory, it's not, the transfer to Red Onion is not a change in conditions of confinement that triggers a due process violation, nor is it an adverse action that supports a
It's not,
First
the
Amendment
transfer
retaliation.
to Red Onion is not, are you trying to say it's the same thing? It's no
Yeah,
difference?
well, Your Honor, and to clarify, if the transfer had been to Red Onion Seg, the actual, the maximum or supermax or whatever word you want to use to define it, section of Red Onion, the Commonwealth concedes that would be a change in conditions of confinement. He was sent from the general population at Sussex 1, which houses 4 and 5 prisoners, to the general population at Red Onion, which generally houses only Part 5, Level 5 people, but if one looks at the transfer orders, it actually shows that Red Onion has some 3s and 4s as well. And so, no, if we take a look at the record.
But didn't we say in the first case that there was a liberty interest in not being transferred to Red Onion?
Yes, Your Honor, based on a record that didn't exist, based on the allegations of the complaint that it was something different, and based on a case in Wilkinson that describes something akin to the segregation part of Red Onion, not the part of Red Onion that he was sent to.
Could he have been transferred there as a level 4?
I'm sorry, Your Honor?
Could he have been transferred to Red Onion as a level 4?
I believe he could have, but I'm not 100% certain of that. But I'm willing to concede for the purposes of this argument that he could not have been, but that doesn't change the conditions of confinement. It actually creates a situation in which, as described in the record, Red Onion actually has more staff, and it's actually safer in many ways because of more staff, because you can't.
But are you arguing a different case than you did the last time you were here?
Yes, Your Honor, it's on a different
The
record.
last time you were here, we dealt with the specifics of that case that was before us. And it seems to me, this Gunner business, I don't remember hearing anything about that. Is that new, that as a result of evidence that occurred on the remand of this?
Yes, Your Honor, it's new based on the evidence that was put into the record after discovery and
So
into
we
the summary
now
judgment
have a
motion.
totally different case. The first case being one that was dealing with the specifics of what is alleged here regarding that video. This case saying, oh, that's been overturned or it's out now, and now, but he should have been, he was going anyway because he had these other offenses. That's what we now have, but that's not the case we had. It would seem that if that's the instance, then you would simply tell the district court, maybe short of conceding, but just say, Your Honor, we recognize that, that's no longer an issue in this case. That's now moot. We give him the remedy he wants, or whatever, and overturn that basis, and have the case dismissed, as opposed to a judgment on it. I mean, if someone brings an action and you give him a remedy, which I don't know if overturning is the only remedy he wants, but basically you say there's no more case because what we were contending here no longer exists. I don't know, did you say the video could have or did show, couldn't show one way or the other? Or
Yeah, the Commonwealth's position has been throughout that the video wouldn't have shown anything that would have helped him anyway. But that has been the position of the prison officials.
But it didn't show anything to help the Commonwealth either,
Correct, Your Honor.
because it showed something.
Because there wouldn't, well, no, because there would be no.
And
there would
the end
be-
result is, we don't know because you wouldn't show the video and you didn't preserve the video. So,
Yeah.
I mean,
There wouldn't be-
it's a procedural thing that seems like, the only thing that makes this case important is, how do we keep this from happening again?
Well-
Because it seems like common sense should have taken care of it in the first instance.
Well,
But
to be-
what concerns us now with Judge Gregory's, I'm gonna let you talk, but I want to make sure we address Judge Gregory's concern and perhaps mine, and that is, I feel like I'm hearing a different case than the one that was previously brought to this court. And you say, well, we developed facts on it. We developed facts. And I'm wondering, when cases go back, I don't know how much a case is retried on remand, even from a defendant's perspective or from the government's perspective. And I don't think I've heard one where you said, well, that didn't matter now, because there's a bunch of other stuff that he was on his way to being sent anyway, which seems like a different case to me.
Well, I have a few answers to that, Your Honor, because there's a lot to unpack there. But first of all, I want to be clear that there could not possibly be any video of the incident itself because it occurred in the showers, and there's no video in the showers. We would be here on a whole different case if we put video in the showers in a prison. But to be clear, in my experience in appeals, this happens all the time, that when a case is remanded after no discovery, there is then discovery a completely different factual record, and then a completely different decision that comes down after the facts have been developed. That's all that's happening here, is that there's a different decision that came down after the facts were developed in discovery. To get specifically to the spoliation issue, on the spoliation issue, we have a situation where, as Mr. Shaw concedes, there was a period where the magistrate had asked for supplemental briefing. The magistrate asked for supplemental briefing, says, I want supplemental briefing in 5 days. 3 days pass, and the district court indicates in a text-only order that the district court plans to grant summary judgment. Then Mr. Shaw does not use those 5 days and supplement anything. Does not provide the supplemental briefing, does not identify to the district court that supplemental briefing was ordered or anything like that. And so therefore he's forfeited any concern about spoliation. Between that and the fact that ultimately the spoliation relief requested would not have made a difference, the spoliation issue is irrelevant, because the relief they requested is a concession that it would have shown that he was not there, that it was a case of mistaken identity. As I've mentioned, that doesn't make a difference. The other thing that they've asked for, I don't think would be relevant relief, which is an assumption that Mr. Adams had seen the video, but that's not a normal relief for spoliation.
Does the video affect the First Amendment retaliation claim?
I'm sorry, Your Honor?
The First Amendment retaliation claim that's made here, does the video have any impact on that? Could it have had an impact on that?
No, Your Honor, because there's no, because first of all, there's no sign of the fact of the argument, the fact of first of all, there's no sign that anyone even knew about the complaint on the video. And second, importantly, there's the fact of, there's the separate fact of this not being an adverse action to transfer him to Red Onion. He had already been at Wallens Ridge. That's in the record at 83-1. He had already been to Wallens Ridge. He went to Sussex. This transferred him to Red Onion. He spent less than 2 years at Red Onion, I think. Then went back to Sussex. Then engaged in the same conduct 3 more times. I think it was 3 more times, as established at JA 1089. And then got transferred back to Red Onion. And now he's in Red Onion now. This is the normal course of things in prisons, is that people get transferred among populations of similar character. And in this case, Sussex.
I'm disturbed by your argument, and frankly by the district court's finding that seems to entirely discount Shaw's personal experience. There was evidence on remand, there's evidence that he put into the record that his experience was different at Red Onion. And the basis of the district court's finding entirely disregarded that evidence, and that strikes me as an issue of material fact.
Well, Your Honor, I don't think it is an issue of material fact for 2 reasons. First of all, or in 2 ways. So, first of all, it is merely a scintilla insofar as he's talking about things that are generally not, are somewhat fantastical, like the notion that there's a gun pointed at him everywhere he goes, and that's disputed in the record, and it's also not to be credited, I don't think.
Isn't that the role of a jury, to decide whether evidence should be credited?
Only if evidence is at least somewhat credible. And I mean, I do think that there is a gatekeeping function for the district courts on things like that. And second, none of this amounts to a change in conditions of confinement. Complaints about not having a microwave or not having ice dispensed, that's not a change in conditions of confinement strong enough to create a right that requires a particular amount of due process, or to call it retaliation. It's not a change in conditions of confinement. It is at most something of an inconvenience. But there is evidence in the record establishing that things like more lockdowns and things like that are not issues that involve, are not credible based on the facts of the case, and based on the facts of the confinement at Sussex and at Red Onion. and at Wallens Ridge. And so that might be one of the reasons that a lot of the focus is on this description of Red Onion as maximum versus Sussex as a 5, but that description elides the real issue, which is that he was sent to the 5 area of Red Onion. He has not seen the max area of Red Onion.
Well, he alleges that there was more exposure to gang violence, more restriction to his cell, more being held at gunpoint. That's not having access to a microwave.
Well, yeah, I agree with that, Your Honor, but at the same time, it's also not a change in conditions of confinement that
A change in
his-
conditions is not being confined to his cell more than he was previously? That's not a change in conditions?
Not to the extent that it is just, I'm running out of time. May I have leave to answer your question?
You may.
All right. Not to the extent that it is an incremental or anecdotal belief as to more time in a cell as opposed to a policy of the prison system where the policies are similar to the same as established at pages JA 355 through 358.
It's not just policy, it's population is what he's talking about. He's saying that, it's been more times when you're gonna be locked down because of the nature of the population. Exposure because of the nature of the population. It's not policy. You live with the population, the people. Maybe you have to abide by some of the policies, but you live with the population. That's what he's talking about. In the sense that he says you got to move around, you have guns. You have weapons, I should say. You have weapons, and that kind of thing. It's just, it seems interesting that the case is sort of, I don't know, once you got to the point, this is just an administrative matter, I can't see why the Commonwealth didn't inform the district court and whoever and say, listen, mea culpa, this charge against him has nothing to do with it, this case is over, this is an administrative matter of a transfer due to his prior behavior and his self-classification as a gunner, and therefore there's no reason that this should continue. I just don't understand why that wasn't done a long time ago. And now, and Mr. Breckenridge, not disparaging you, I know you as a great attorney and honorable and that kind of thing, and you have to argue what you have, but to come and tell us all this now, a new horizon about this case in a context is really befuddling. But anyway, with that, unless my colleagues have further questions.
Just one quick question. Qualified immunity, you're seeking that only on due process, on the due process claim?
No, Your Honor, we'd seek it on both of the claims.
All right. Mhm.
Thank you, Mr. Breckenridge. Now, I'm correct, this is Ms. Bagwell. Right.
Your Honors, beginning with defendant's argument that Mr. Shaw's transfer was based on a history of this type of behavior, the record simply does not support that contention. In fact, it shows on page 652 in the Institutional Classification Authority Hearing Notification Form that his transfer was based on, quote, an administrative transfer based on 137 conviction, and the word conviction there is singular. There is no evidence that other past behavior was considered in the choice to raise his security level in order to transfer him to Red Onion State Prison. In fact, his last charge was 2 years prior. And in the reclassification security level score sheet documented in the record at JA 650, nothing is checked for behavior beyond this singular conviction.
Were the prior convictions overturned?
Your Honor, multiple of the prior convictions were overturned. Notably, the ones that were not were 2 years prior to this 137 conviction. And at no point in those 2 years did defendants make any decisions to increase Mr. Shaw's security level. It was only after this specific conviction that those proceedings began and that the increase in his security level was raised and that he was ultimately transferred.
If it's right that the prison officials, I'm moving to the First Amendment issue because we didn't have a lot of time to talk about it. If it's right that the prison officials met their burden to establish a valid explanation for the transfer, which let's just take for a minute, suppose that they did. Is there evidence in the record that suggests that that explanation is improper?
Yes, Your Honor. Because the defendants were aware that Mr. Shaw had this right to request the documentary evidence, and there is evidence that they were on notice that he repeatedly sought that, and that they retaliated against him for repeatedly writing to them, requesting that information. He also wrote to the warden of the prison as well to Karen Stapleton at the VDOC. And those letters and messages were responded to by these various defendants. For example, Defendant Foreman marked that he was not going to review the rapid eye, but that he received the complaint, as well as Defendant Lebaugh and Defendant Adams. So to the question of whether the defendants were on notice, they simply were in this case. They were responding to these complaints and interacting with them, and they knew without a shadow of a doubt that Mr. Shaw was requesting that footage.
But the way the burden shifting works, he has to state that he experienced an adverse action, then the burden shifts to the government to provide a reason for the action, and then the burden shifts back for him to say why that reason isn't the actual reason. And here you're saying, well, there were sort of two separate things happen, but I'm finding trouble connecting the two.
Yes, Your Honor, your point is well taken. But Mr. Shaw's contention here is that he should have never had his security level increased because, but for the defendant's failure to review that video footage, they would have been unable to raise his security level and ultimately transfer him. Notably, there was some debate earlier as to whether a level 4 inmate could be transferred to Red Onion. They could not. It was only by raising his security level to level 5 that they could then transfer him. And going to what the video would have shown, Mr. Shaw claims that it would have shown him not even in the area of the subject behavior, in fact, sitting on the stairs rather than in the showers. So this is not just a case of a mistaken identity between inmates who were in the showers, but rather Mr. Shaw claims that he was not visible at all in that footage.
So what's confusing me, and maybe I just need you to help me on the factual thing here. As I understand, it seems like the government is arguing, well, all of that conduct that you're saying gave rise for him to go to Red Onion, that's been overturned, or that's not the basis. After we did discovery, he was sent there for all these other reasons, of which is not part of this video or any of that incident there. Is that what's being argued here?
Your Honor, it does seem that it is the government's contention that it is just because of Mr. Shaw's history and self-identification as a gunner that he was ultimately transferred. But again, the record simply does not reflect that.
Well, the question is, just because he had done that, just sort of play it down, it seems to be only because what they're saying is we didn't use the word concede. That probably would have helped if you said concede. But we basically saying that's not the conduct he was sent there for. He was sent there for this conduct. And if the trial court, upon remand, would you have any concern as to whether the trial court can take in additional evidence that would support that he was going there, I guess, anyway, or this was sufficient to do it?
Your Honor, we would not be opposed to the trial court making additional findings on that. But again, the record is sufficient today to decide that it was but for this singular conviction. Again, a history of nothing in the 2 years prior, and then the temporal proximity within a few weeks that his hearing occurred and that his security classification was increased. And one more thing to address here, as far as...
That's said, but I'm saying, we've got to look at the record. It was but for this conduct. He's saying it's not but for because we basically said, no, we're giving that up. This is the basis right here. This is the only evidence here. It's kind of odd when it comes back on appeal because the first time we came around, it was pretty much this was it, seems to me. Second time after you do get all this evidence in, you says, no, we'll concede that that's not enough. But this did it. So how do you counter that?
Your Honor, I see that my time has expired. May I briefly answer your question?
Yeah, you may.
It does seem in this case that course has changed, and that now the argument is that it's this history of gunning that has led to the increase in security classification and the ultimate transfer. But again, because the record at JA 652 indicates that it was this singular charge that led to Mr. Shaw's security level increase, and because he was not afforded adequate due process at his hearing by the prison officials refusing to produce that video footage, and because, as this court already recognized last time, it was an adverse action for him to be transferred to Red Onion, we would ask this court to reverse. Thank you.
Thank you, Ms. Bagwell. Mr. Birch, you didn't introduce your students.
Yes, Your Honor, I'm sorry.
Yes, we always like to know, we already know how fine they are and how well they did, but now just tell us, in fact, from which they hail and where are they studying?
Sure, Your Honor. Mr. Shane Cresswell is a third year at University of Georgia. He's going to be a public defender after he graduates. And Mrs. Rose Bagwell, she's also a 3L at University of Georgia. She's going to private practice after she graduates as well.
All right, well, good to have you here, and as always, you're court appointed, and we, on behalf of the Fourth Circuit, I want to thank you for your services. We depend on lawyers like yourselves who come and help us and try to deal with these challenging cases, and we appreciate it very much. And obviously, Mr. Breckenridge, we appreciate your representation of the Commonwealth. With that, we'll come down and greet counsel and proceed to our next case. Ms. Katsky?
Good morning, and may it please the court. Richard Katsky from Duke Law School. Today, the appellant will be represented by Christian Ross, who will be arguing, and by Molly Pines and Emma Klein, all third-year law students at Duke.
Thank you. Welcome.
May it please the court, Christian Ross for the appellant, Mr. Patrick Nichols. Mr. Nichols did what he needed to do to state an excessive force claim, but the district court failed to recognize the sufficiency of his factual allegations under Graham, and it failed to recognize that his lawsuit was against both officers Bumgarner and Schmidt. Mr. Nichols alleged that Bumgarner and Schmidt approached him with an arrest warrant. Bumgarner then grabbed him by the arms, slammed him to the ground, and broke his arm in multiple places. And then, when he was already on the ground, Officer Schmidt pressed his knee into his neck so that he couldn't breathe. And after the officers did all these things, they did that despite the fact that Mr. Nichols alleged that he had done nothing to threaten, resist, or evade them. And Mr. Nichols alleged that there was video evidence that would show exactly what happened during his arrest. Mr. Nichols may not have pleaded with exhaustive detail, but he pleaded enough as a pro se incarcerated civil rights plaintiff to plausibly allege that Bumgarner and Schmidt used disproportionate force. And this court should therefore remand to the district court and allow Mr. Nichols to prove his case. Starting with the Graham analysis, the most important factor is whether an arrestee poses an immediate safety threat to the officers on the scene. And this factor favors Mr. Nichols because, as alleged, the officer's life was in no danger or harm. In fact, any danger in the circumstance was exactly the opposite. When Bumgarner had thrown him to the ground and broke his arm, and Schmidt pressed his knee onto his neck, Mr. Nichols alleged that he feared that his life was in danger. And indeed, the fact that there were multiple officers on the scene outnumbering Mr. Nichols even lowers the amount of force that would have been proportionate and the possible threat that Mr. Nichols could have posed. And these are factual allegations that Mr. Nichols was in danger, was not the danger himself.
What is our standard of review for this case?
Your Honor, the de novo review for the Graham analysis of excessive force.
What is the quantum of evidence that we have to consider when looking at a 12B6 motion of dismissal?
Your Honor, looking at the factual allegations that Mr. Nichols has included in his filings.
And to what extent, what is the weighing of those? How do we view those factual allegations? We can look at them, but what must they show?
The factual allegations have to show that there is a plausibility that the officers used disproportionate force under what this court follows under the Graham analysis, and specifically, those factual allegations are afforded the presumption of truth when they're well pleaded.
So we've been very, we've had different standards in terms of pro se, maybe even pro se who's in prison, as opposed to someone who's represented by a lawyer. And to what extent do we need to employ that here? Because it seems clear if this individual had had a lawyer, you would probably accept dismissal of this complaint would be proper. Is that correct?
Yes, Your Honor. If Mr. Nichols had been represented, then it is likely proper that his complaint would have been dismissed. But here, because he was proceeding pro se, this court applies a liberal construction to his pleadings. And that liberal construction means that he should have been afforded more generosity and more leniency with following procedural requirements, and to look at the substance of his arguments to raise the strongest arguments that they suggest.
So you just want to argue about excessive force. You don't want me to ask you questions about why Officer Smith was not in this on that complaint?
Your Honor, I'm happy to respond to questions about either the Graham analysis or that Schmidt was not in this complaint, but we believe that district court erred in both cases.
He was not served.
No, Your Honor, he was not served, but that error was on the district court. Here, the district court's policy is that for incarcerated plaintiffs who are proceeding pro se, the district court orders the clerk to effect service of process. So Mr. Nichols here filed his initial complaint pro se with the court, and the court then directed the clerk to serve process.
And they did, based upon the one that was listed in the caption. But Smith was not in the caption.
Correct, Your Honor. We believe that the district court's mistake was in not recognizing that Mr. Nichols was trying to sue both Officer Bumgarner and, at that time, an unnamed officer. And so the district court should have...
How would you identify an unnamed officer to be served?
So, Your Honor, in the first instance of his initial complaint, we think that the district court's service should have gone to Officer Bumgarner. But after Mr. Nichols identifies Schmidt by name in his amended complaint, at that point, the district court should have recognized that that was another party that was appropriate to be served. And under Gordon, the district court had a responsibility to instruct Mr. Nichols in his amended complaint to specifically remedy anything that could be cured in his initial complaint, such as not having the party named in the caption specifically.
If we agree with you on your first argument regarding sufficiency of the pleadings, and we disagree with you in your second argument, couldn't your client simply amend the complaint on remand to add Mr. Schmidt?
Yes, Your Honor. If this court gives a remand with leave for him to amend, then that could be resolved in the district court. We think that Mr. Nichols did sufficiently identify Officer Schmidt as well in his amended complaint, and that this court should adopt an approach like the 9th and 10th Circuits have done, which is to look at the body of the complaint, and so that when it's clear from the face of a complaint that a pro se plaintiff is bringing suit against multiple identified officers for substantially the same conduct, that should be sufficient. But even if this court disagrees that that is not the rule proceeding forward, at the very least, Mr. Nichols should have the opportunity to amend his complaint in the district court. But speaking to the factual allegations that Mr. Nichols has alleged here, he's alleged in his own words, in everyday language, as best as he can, what happened to him during his arrest, about his actions, about the actions of the officers, and about the circumstances. And he didn't just ask the district court to take his word for it. He alleged repeatedly that there was video evidence that would, in his words, quote, it was showing what happened during the arrest. And he said this to show that not only did the officer's life not be in danger or harm, and that he wasn't doing anything, but that there was another source of verification for those allegations.
Did the district court review that video evidence?
No, Your Honor, that video evidence was not reviewed in the district court.
Do you believe the district court had an obligation to review it?
No, Your Honor. My understanding is that the video evidence was not ever obtained by Mr. Nichols. He alleges in his notice of appeal that is in possession of the county police. And so my understanding is that he has tried to subpoena but unsuccessfully get those video records. Mr. Nichols was trying to describe a negative, that he wasn't a threat during his encounter with the police, and that he wasn't doing anything. And that specific way of trying to describe a negative is reflected by his everyday language they used to explain what had happened to him. And he also alleged that he wasn't resisting and he wasn't evading arrest. He specifically says that he did not do nothing to the officer. And that allegation most straightforwardly means that he wasn't trying to fight back and he wasn't trying to run away. And to the extent that that statement is ambiguous, this court's precedent in Woody v. Nance is to interpret pro se plaintiffs' allegations that are ambiguous in their favor. And there's nothing proportionate about throwing a non-threatening, non-evading, non-resisting arrestee to the ground with bone-breaking force, and then applying a knee to the neck of someone who's already subdued. And Mr. Nichols' allegations, they support an inference that not only did he not resist or evade, but once he was already on the ground, he likely could not resist or evade, and then that is when Schmidt then pressed his knee upon his neck. And again, these are factual allegations about Mr. Nichols' perspective of his own conduct and that of the officers. And in addition to the Graham factors, this court also looks at the severity of the injury that a pro se plaintiff brings. Mr. Nichols alleged that he received multiple serious injuries at the hands of Baumgartner that required immediate hospital treatment and have caused him a lifetime of damage, including medical treatments and chronic pain. And this is much more than what this court found to be, quote, severe injuries in Jones v. Buchanan of a broken nose, lacerations, and bruised ribs. And Schmidt's additional force of a knee on Mr. Nichols' neck after he was already on the ground only compounds the unreasonableness of the force that the officers used.
So the inclusion of Schmidt here and what you say based upon not the first complaint but the amended one, where he is mentioned but not in the caption of it, the concern is courts are flooded with pro se complaints. And you're correct that typically this court will direct the clerk to serve the individuals with their officers there, but they're not named in the complaint. The clerks don't go looking through it to see who to serve. They just look up here at the caption and see who to serve. The district court, I suppose if you read it very carefully, you can figure out, well, he ought to be suing this guy too. And there may be reasons why a defendant may choose to sue someone or not to sue, but this court can make that count. I mean, there's a certain amount of, I guess it's paternalism of being a lawyer for the defendant that may have a line, but the concern would be, what is the limiting principle on that? If, a pro se person files a complaint, and let's say, and this is not meant to be facetious, but just illustrative. He names a non-existent person or Bugs Bunny in the caption, but in the body of it, there's a whole bunch of names or whatever. I mean, it's like the court has to weigh that. But as Judge Berners pointed out, apparently you can still do this. I assume that the statute has not run, because you say you can still do it now, but you know, even when it comes up, why wouldn't you seek that to be cured to say, I want to put his name in the caption and I'll send it back?
So, Your Honor, to answer your
There's
question.
two questions. I know I gave them, but do the best you can.
So let me answer that, yeah, in a couple of parts, Your Honor. First, to the limiting principle. Here, we're not asking for this court to adopt a rule that district courts will have to exhaustively and closely read every pro se complaint that comes in to identify any possible person named and then make a judgment call as to whether that person ought to be read as being in the caption. Instead, we're asking that this court consider something far more modest, which is that when it is plainly, reasonably clear from the face of the complaint, as is here, that substantially the same conduct is at issue with multiple named parties in the body of a complaint, that a failure to include those parties in the caption should be viewed as a procedural infidelity on part of the pro se plaintiff, that under a liberal construction should be construed to be as complying with those rules. But to Your Honor's second question about how this is going to play out, I think rather than the named parties of an imaginary person or other folks named there, we're not concerned about artful pleading in this case. In this case, it's clear that Mr. Nichols' complaint, his amended complaint is essentially a long paragraph. It's barely over a page long. It's not particularly burdensome on the court to handle those things in that instance. And so we don't think that that is a concern about there being too much for the district court to look at when it's plain from the face here. Your Honor, does that respond to your questions?
Yeah, it's still kind of there because the client got a second shot.
Oh, you're asked to respond there.
Yeah, and they sent that back. I mean, he didn't ask to put in more detail, but he didn't add much, and he didn't submit in the caption, and then the court dismisses it with prejudice.
So, Your Honor, to respond to that, I think the issue there is that the district court, in its initial dismissal, did instruct Mr. Nichols to add more factual detail, and we believe that he did. He named Schmidt specifically in his amended complaint. He included the exact address of where it happened. He included more allegations about what actually happened during his arrest. But if there was a deficiency in naming someone in the caption, the district court never gave him any instructions or indication that he did not, that he needed to do that. And in fact, the second, his amended complaint form has instructions that say that it needs to match identically who he lists as defendants to match the caption. And we think it's reasonable that a pro se plaintiff is going to have the caption of their amended complaint match what the caption was in the order that the district court gave them. Mr. Nichols doesn't have a sophisticated understanding to know that in the amended complaint, that's where he needs to also be including folks in the caption. And specifically here, the statute of limitations for Mr. Nichols' claims, they ran shortly before the district court's initial dismissal order without prejudice. Mr. Nichols filed timely after that, and we think that to the extent that the statute of limitations have run, equitable tolling should apply. But in this instance, the ability to have leave to amend should cure the defects, and the district court should have given him that opportunity. Turning to the last of the grand factors, I want to address that this court may take judicial notice of the facts underlying Mr. Nichols' arrest. But even those facts support Mr. Nichols at this stage. And the reason is because the offenses for which he was arrested are not inherently violent. Public court records show that Mr. Nichols was arrested for theft, forgery, and second-degree burglary, none of which require violence as an element. And neither does anything in the record suggest violence on Mr. Nichols' part. And so it wouldn't have been reasonable for the officers coming to the scene to assume that he was maximally dangerous. And once they got there and they saw that he was not an immediate threat, that he wasn't resisting, not evading, even less force would have been reasonable for them to use. And at the very least, this court should not take an inference against Mr. Nichols at this stage. That would turn the motion to dismiss standard on its head and not give Mr. Nichols the proper protection of the law that he deserves as a non-moving party.
Should we take into consideration the fact that he was arrested on the basis of an active warrant and not an ongoing crime?
Your Honor, I think the fact that it's an active warrant changes the circumstances for what officers may expect upon trying to effect that arrest. If anything, that supports Mr. Nichols' claim even more because the officers would have had more concrete information about what he was likely to be either doing or what kind of threat he might pose. And again, once they get to the scene, then it's going to be more information for them to see that he is not a threat, not resisting, not evading, and that should be sufficient for their force to be less than what they used, and it's more disproportionate the way that they did it. But even this court doesn't take judicial notice, Mr. Nichols still alleged enough to state a claim, because you cannot take inferences against him at this stage without going against the motion to dismiss standard. At the very most, this factor is empty, and Mr. Nichols should still be able to state a claim, because Graham is a totality test. And even if he has a factor that weighs against him, this court held in Lewis v. Carabello that even that factor weighing against them, a pro se plaintiff can still prevail under the Graham analysis. Thank you. I'll see you further questions.
Thank you, Mr. Ross. Ms. Nunley?
Good morning, and may it please the court. My name is Kristen Nunley on behalf of the appellee, Officer Baumgartner. Your Honors, courts are obligated to liberally construe pro se complaints, but liberal construction is not without limits. A pro se plaintiff still must allege facts that state a cause of action. Here, the district court gave Mr. Nichols ample latitude. It provided him with an opportunity to amend his complaint and even provided him with a roadmap of the exact facts he needed to provide in order to state a claim of excessive force. Mr. Nichols failed to provide any additional facts in his amended complaint, and the district court properly dismissed it, and this court should affirm. An excessive force claim is analyzed under the Fourth Amendment's objective reasonableness standard as outlined in Graham v. Connor, and the factors that this court considers in its reasonableness analysis include the severity of the crime at issue, whether the suspect posed a threat to the officers or others, whether the suspect was resisting arrest or attempting to flee, and the extent of the injuries. But ultimately, the overarching inquiry is whether the force used was proportional under the circumstances. Mr. Nichols failed to provide factual content about the Graham factors.
Well, he stated in his complaint that there was video evidence, so he incorporated that by reference. And it's my understanding that district courts often view video evidence before ruling on motions to dismiss, and this district court judge, in this case, didn't view the evidence, the video evidence.
Your Honor, there is no body cam video evidence of this arrest. And as far as I know, Mr. Nichols has not requested any video evidence.
He alleged that there was video evidence in his complaint,
did.
however.
And he could have described what the video evidence would show. But I know that there is no body-worn camera footage of this arrest. So
Well,
I
in
don't know.
describing the arrest, I think he was describing, in his own words, as a pro se
Right.
litigant, what he would expect the body cam video to show.
Yes, Your Honor, and how he expressed that is not sufficient to state a claim of excessive force. If I can start with the first, sorry.
Well, let me get to the nub of this thing here. It's this. I think Mr. Ross said it well in terms of his description. How do you prove a negative? And that is, at this point, pleading, he said he had an arrest warrant. Police officer came and approached him. And when he did so, he went from approach, he's alleging a 0 to 10. 0 meaning he's there, got the warrant, and he grabbed him and threw him to the pavement,
Yes, Your Honor.
causing his arm to be broken. And the next thing that happened, the other officer put his knee on his neck, which momentarily prohibited his breathing. What else does he have to show at this point in terms of, it's like, if that's what happened, what is he gonna say? Well, let me see, the sky was blue just before he snatched me, and it was when it was raining that day. You know what I'm saying? And I've seen it, and otherwise you think that's kind of strange, but I've seen video situation where people just dragged out immediately and just, that's what happened. I mean, so is that incredible? And what does he have to fill in? If there's nothing to fill in, what is that? He can't make it up.
No, Your Honor, but
What is he supposed to do? That's all, just a common sense question. What do you do if that's what's happened? He went from warrant for your arrest, shoo, to the floor, to the ground, broke his arm, then got on his neck. What is it? What else? If that's true, in which we have to assume it is, what is there else to say?
well, Your Honor, I think the district court
I'm
explained.
not asking about the district court. I'm asking you.
Okay.
What is it there to say?
Instead of saying I did not do nothing, he could have said I was complying with commands.
Well, he's not, wait a minute, the other one there's grammar. He could have, syntax, he didn't have to use that, again, well, come on now, he's
He could say, "I listened to the officer.
Well, we know.
I didn't
You've
run
seen-
away."
Excuse me, you've seen the record. He said, I didn't do nothing to him. He didn't use to, wrong preposition. I mean, but he basically said, I didn't do anything. What else can he do? I'm serious about that. This is not about law. We're talking about just common sense. Assuming that's what happened, which we must do, what else do you say if that's what happened? He approached him with the warrant, he threw him down, and his arm was broken, and the other officer, while he's on the ground, put his knee there. I don't know what happened. I wasn't there, but that's what he pled as what happened. So you tell me, what else was he supposed to do?
I think he could have provided facts about what his actions were during the circumstances of the arrest.
He was minding his business. He was standing there. That's what he said. I'm there. The
We don't know
officer
that he was
approached him.
standing there.
But
He could have been running away at the time.
He could have been running away.
If the officer approached him and said, "Excuse me, Mr. Nichols,"
Well, as he said, he approached him and threw him down. Where's the running part?
I'm saying I did not do nothing gives us no factual content
It
for what was
does.
happening. When did he not do
You don't
nothing?
accept
Was it
it.
after he was already
Counsel,
slammed to the ground?
Let me try a little bit, okay? You don't get to control the narrative. You weren't there and I wasn't there.
Mm-hmm.
He described it as exactly what he said happened. He approached him and he had the warrant, and he threw him down on the ground. Now, I don't know, discovery might show that that's wrong, or a trial, or whatever it is, but I just don't see it. Obviously, if you're a lawyer, and if you were in that situation, you'd probably have 10 pages before you get to, well, his arm touched you, because you're trained. But all he can do in the humbleness of the human experience is say, this is what happened to me. He came up to me, and he snatched me, put me on the ground, and broke my arm. And y'all people going to school, you may be able to put fancy words, but that's all I can say in the vernacular of the harm. I just don't understand why he has to do more.
Because, Your Honor, the district court provided him a roadmap of the exact facts to include. He was given instructions, specifics, to include in his amended complaint so that the district court would have enough information.
What did he tell him to do?
The
Make up
district
something?
court specifically said,
Yeah, no, the court, he can't make up something.
I'm sorry?
He can't make up what didn't happen.
no, sir, but the district court said to add additional facts about the circumstances of the arrest, the severity of the crime at issue, Mr. Nichols' actions, and any potential threats which existed to Mr. Nichols, to the officers, or to bystanders.
That's a list, that's a roadmap?
That's a roadmap. Those are
That's not a
specific
road-
instructions.
That's a roadmap. That's like, if these things happen, then tell us what happened. If those things didn't happen, what are you gonna put there?
Mr. Nichols could have said there were no bystanders around. That would give us information about whether he was a threat to others.
If he doesn't know, what would he say?
But he would know about the circumstances of his own
So in other
arrest.
words, it would make a difference that, there were no bystanders. What difference does that make in the pleading in terms of pleading his case?
One of the Graham factors is whether the suspect posed a threat to the safety of the officers or others. If an arrest happens in the middle of a busy street, the public may be at risk, and that's important information in terms of the proportionality of the force.
Well, if it is a problem, the police officer must have created a problem in the sense that he chose that time to approach him. and there's no evidence that he had a gun or anything like that. So if there was something that the officer would have created, wouldn't he?
No, Your Honor.
Why not? I mean, he approached him. He approached him at a point where he could subdue him. There were two of them. And apparently he did it pretty quickly, according to him. He snatched him and threw him down on the ground. I mean, you're putting more on, to me, a litigant that's required.
I think that what's required is for him to provide sufficient content for the district court to determine whether the force used was proportional. I think it's very important that Mr. Nichols provided no information about the underlying crime, and now for the first time on appeal asks this court to take judicial notice that at the time of the arrest he had outstanding warrants for theft, forgery, and second-degree burglary. But asking for judicial notice of a fact does not mean the same thing as pleading a fact in his complaint.
Well, at the motion to dismiss stage, we're to draw all inferences, take the allegations as true, draw inferences in favor of the non-moving party, and particularly in a case like this of a pro se litigant, to construe the complaint liberally. And here, it strikes me that the facts that you're alleging are missing in the complaint are all negatives. They're saying this didn't happen, there weren't people there, I wasn't being violent. And that, doing so is drawing inferences in favor of your client.
Your Honor, I would say that we're not asking for inferences to be drawn in Officer Baumgartner's favor, but I'm saying that there are no reasonable inferences to be drawn unless there are well-pleaded factual allegations.
Well, isn't it a reasonable inference that there were, one could infer, whether it was or not, that there was nobody else, that there were no close bystanders closely nearby if that's not stated in the complaint?
I feel that that would then mean that we could plead, basically, I did nothing, the officer was not in danger, and that would always be sufficient for an excessive force claim, but that would render motions to dismiss obsolete.
Well, there's much more here than I did nothing and the officer wasn't in danger. There's allegations of, pretty specific allegations of actions of the officer. There are allegations of what those actions of the officer resulted in. There was a statement that the officer said that they had a warrant, and so the warrant is referenced in the complaint. Again, this individual is not an attorney and did not, it appears, have access to counsel. There are allegations about the specific pain the plaintiff has suffered since the arrest, and what he experienced at the time. So it's not as bare bones as you're suggesting. It's simply missing some of the negatives.
Officer Baumgartner's position is that the facts or conclusory statements, I would argue, that Mr. Nichols includes in his complaint and amended complaint are insufficient for the Graham factors, and that the district court provided him an opportunity to amend with instructions, and that Mr. Nichols failed to add any additional facts in his amended complaint.
The problem in cases, anytime we're dealing with construing a pro se complaint, you're struggling with it, we all struggle with it, because it, at least from my perspective, it tells me that sometimes you're better off not having a lawyer. Because if you had a lawyer, the other side's already said this would be dismissed. Right. But as from what we can glean here, we not only look at the complaint, and I think Iqbal and Twombly doesn't really squarely cover this sort of situation, we draw inferences and we look at what's here, and that's maybe what's being alluded to here by Judge Byrne and Judge Gregory. When you look at what he actually said, even what the court, that litany of things the court said there, and I'm listening to that litany and I'm saying, well, some of that stuff up there, he's asked him, well, tell us that you don't get the relief, which is, tell us that you didn't resist or something like that. Well, what he's going to do is say, I resisted, and no one's going to put that in a complaint. I mean, that may come in the answer on it, but the complaint part about it is when he says, I didn't do anything, basically, whatever, I didn't, and they did this for no reason. That tells you right there, if there's no reason, even on a layman term, that means I didn't do anything that gave them a reason. I didn't resist, I didn't do other things to it. Those are inferences you can make from it. It doesn't say specifically. And again, the struggle you got is, a lawyer's complaint would be different than this. And that's where we are on excessive force. I mean, the fact of the matter, if you take it, as Judge Gregory reads it, that 0 to 10 happens, which is basically the officer walks up, he knows the guy has done something, whatever, and then next thing he knows, he's slamming into the ground. Now, I don't know how big this guy is, but to break someone's arm in 2 places, you got to do a good job for that. And then to throw your knee on his neck, I don't know what the circumstances of that. But that's all stuff that comes out. We're at the 12B6 stage. And ultimately, I don't know where it goes in terms of it. I already know where it goes with qualified immunity, that sort of thing. That wasn't even brought up there, but that's down the road on these cases here. But that's where we are. We'll probably keep going back and forth, and your job is to say, well, Mr. Bumgarner said, no, he didn't do this, he did this, and all that, but that's a factual thing. And 12B6, if we're doing this liberal construction, and isn't it somewhat different pro se as opposed to pro se in prison? It seems like it's even more so if you're in prison, isn't it?
Pro se incarcerated plaintiffs are entitled to liberal construction, yes.
But even more so than just pro se who's not in prison. Is that the case? I mean, I'm asking.
I believe Mr. Nichols did cite a case to that effect.
Yeah, so I mean, so he's got it even a heightened level of what you call liberal construction of it. And probably we can go back and forth on it, but ultimately today it's just it's a call as to what you infer on it and what you don't. But, and I think we'll make that decision, but talk a little bit about Schmidt and because
Yes,
there
Your
is a
Honor.
concern there that simply putting a name within an amended complaint should trigger the court to then serve that one. But it seems to me you might get there here because he says there is an unnamed one in the first one, not in a caption.
Yes.
There's an unnamed, did he name somebody? I mean, it seems like to me that might trigger,
Your
you
Honor,
need to do something.
right before I get to Schmidt, can I address one thing that you mentioned?
Yes, please.
You said, I don't know how big this guy would have been, but it must have taken a lot of force to break his arm. And I think it's very interesting, in a case before this court, Smith v. Ray, that was a fact that a plaintiff pleaded, that she was a small woman compared to a large police officer, and that was to the second gram factor,
But you see,
whether she was a
that goes more
threat.
to the sufficiency of the pleadings. In other words,
Right,
do
I
you
just wanted to point
have-
out that
see,
was-
He didn't have to plead that.
No,
That's
but it
I
is
only
something.
pointed that out just as a
Yes.
matter of curiosity.
Understood.
That throwing him down to the ground quickly, I mean, either someone's pretty daggum strong to be able to put someone down the ground like that, or small, and to do it that manner. I don't know the circumstances, but we're only dealing with just those. But speak a bit about Smith.
Yes,
because
Officer
that's
Schmidt.
interesting.
Officer Schmidt is not a defendant in this case. For the first time on appeal, Mr. Nichols contends that the procedural history of the case illustrates that since the beginning, Mr. Nichols intended to sue both officers, but this is simply not true. All indications point to Mr. Nichols' intention to sue only Officer Bumgarner. The complaint allows space for Mr. Nichols to write the defendants, and he wrote only Officer Bumgarner's name. And where there was space for other defendants, he wrote not applicable. 21 times he wrote not applicable on that piece of paper. That indicates to us he was intending to sue only Officer Bumgarner. When he wrote his amended complaint, this is JA 53, he again wrote only Officer Bumgarner's name. He left blank the spaces for any other defendants. This shows an intention to sue only Officer Bumgarner. As you mentioned, at all times, the case caption included only Officer Bumgarner. It never said at all. There was no indication that there were multiple defendants being sued. Officer Bumgarner pointed out to Mr. Nichols that Officer Schmidt was not a defendant in this case, and that Officer Bumgarner's understanding was that allegations against Officer Schmidt were being used to bolster the claim against Officer Bumgarner. Mr. Nichols' own opening brief seems to acknowledge this purpose when he argues that the presence of Officer Schmidt speaks to the objective unreasonableness of Bumgarner's alleged use of force. So all indications point to Mr. Nichols' expressed intent to sue only Officer Bumgarner. And the district court cannot interpret his unexpressed intent. We can't read Mr. Nichols' mind. We have to look at how he is expressing his intent. And Officer Schmidt was never served. There was no service of process. And this isn't a case of failing to identify the right defendant. Mr. Nichols sued the proper defendant in this case.
Was it fatal? I mean, if he had put the name in the caption, then you think that that would satisfy it?
If he had added Officer Schmidt's name in the caption of the amended complaint, or if he had added him as a defendant in the space provided for multiple defendants, it would have put the district court on notice, and it could have been addressed at that point.
The district court didn't ask them to amend the caption of the case. It said amend the complaint. And he put his name in the complaint. And I'm just wondering, again, from a pro se person who's being told to go do something, and he obviously didn't talk to a lawyer or something in the interim. It doesn't look like he did. He then goes and, I guess, attempts to do something and send it back and put the name of him there. But because he didn't take that name and stick it right there in the caption, you say that's not good enough. And what he wrote wasn't a long statement. I mean, it was pretty concise, but he named him in there. And what did he say Schmidt did to him?
I believe he said he kneeled on his back, or perhaps his neck.
He said he put his knee on his throat, and then later he says he was wrongful for damaging my arm and putting his knee on my throat, and I couldn't breathe for a second. My life was in danger. And the Ninth and the Tenth Circuits both say that the district courts, and I'm quoting, may look to the body of the complaint to excuse the failure to include an individual in the caption, so long as the, and I'm paraphrasing, complaint makes it plain that the defendant is meant to be a defendant. Seems like it's pretty plain. He uses the word damaging, and then
Yes.
asks for damages.
Yes, Your Honor, but it was pointed out to Mr. Nichols that Officer Schmidt had not been named as a defendant. So he had an opportunity before the district court to assert that he was suing Officer Schmidt as well.
Well, he put the name in there. He put the name in the complaint, but it wasn't pointed out that he's not put up there in that caption. When he came back, he put Schmidt's name in it.
Yes, and when Officer Bumgarner moved to dismiss the amended complaint, Officer Bumgarner said, Officer Schmidt is not a defendant, and Mr. Nichols responded in opposition. This is JA 68.
Who is Baumgartner representing? Is he representing Schmidt or himself?
He is just,
So why
he was
does it
sued
matter
as an
to him if
individual.
Schmidt's
He is-
a defendant in the matter?
I'm sorry.
Why would it matter to him whether Schmidt is in there? Maybe because maybe
Right.
Schmidt's a witness or whatever, but, I mean, seems like that's, again, the trial court is the one that's doing the service of something there. That basically effectuate the service, unlike regular civil cases,
Right.
you do it yourself. Because it's in prison, he's directing the clerk to serve the people
Yes.
who needs to be served, but it's Baumgartner that says he's not named, but at that point, that ought to flag to the trial court, well, he's here, in this here, maybe we ought to go ahead and serve him.
I apologize, Your Honor. I believe I meant red. If you'd like me to respond, or I can
Please,
just close.
please.
I just wanted to finish by saying that once Officer Bumgarner pointed out that Officer Schmidt was not a defendant, Mr. Nichols said that Officer Schmidt, quote, do have something to do with this claim, referencing the claim of excessive force against Officer Bumgarner, and ended with, quote, I do have sufficient facts showing that Officer Bumgarner was wrong by law, end quote. So we would argue that Officer Bumgarner was the only defendant at all times.
Right?
Thank you.
Thank you, Ms. Nunley. Mr. Ross, you have anything for, yes, you have time?
Your Honors, I'd like to address a few brief points. First, to clarify, Mr. Nichols is not alleging that there's body cam footage. We understand him to believe that there is, that there is traffic cam or building camera footage that he says will show what happened during his arrest. But to respond to what my friend on the other side has argued, that Mr. Nichols has not alleged any other additional facts in his amended complaint. Mr. Nichols did allege that Schmidt's name specifically was added to his complaint, that there was a warrant for his arrest is in his amended complaint, that Bumgarner's life was in no danger or harm. That's in his amended complaint. These are things that he adds specifically from the district court's instructions. And we can see most clearly from the amended complaint precisely why his allegations are sufficient and also why Schmidt is a defendant. The amended complaint form was different than his initial complaint form because he had changed facilities. And this amended complaint form specifically asked him to do three things. It asked him to name what happened to him, how he was harmed, and how each defendant took wrongful action against him. And then in that section, he named specifically what happened during his arrest and identifies both by name, Bumgarner and Schmidt, that they were wrongful for damaging his arm and for putting his knee on his throat. That identifies Schmidt as a defendant in his amended complaint. And that's further underscored by his other filings that my friend on the other side also referenced, that he says that Bumgarner and Schmidt together violated his Fourth Amendment rights, and that Schmidt does have something to do with his claim because he stated his name in his lawsuit. And this is also apparent to the defense on the motions to dismiss because they acknowledge in both the initial motion to dismiss and the amended complaint motion to dismiss that he is trying to allege claims against another officer. And that's perfectly consistent with what Mr. Nichols has been alleging from the very beginning, that two officers used excessive force against him. He alleged that an unnamed officer he later identifies as Schmidt harmed him during the arrest and, quote, used force against me, and that his remedy in that initial complaint was against officers plural for the damage they had done to him. If Mr. Nichols had a lawyer, his complaint would have looked different. But at bottom, all the sophisticated language and additional words that an attorney would have been, helped him to use would have meant exactly what Mr. Nichols already pleaded, that he didn't do anything, and that the other officers' lives were not in danger or harm that would warrant the force that was used against him. As a pro se, civil rights, incarcerated plaintiff, Mr. Nichols told his story as best he could in everyday language. That's what he needed to do, and that's what he did. That should be enough to state a claim. Unless your honors have more questions, I'll reserve my time.
Thank you, Mr. Ross.
Thank you.
And as well, thank you for your services and your court appointed, and glad to hear from, was another student with you? Yeah? Would you stand? Yeah, yeah, yes. It's a team, it's always a team effort, yes.
Carlin Pines and Emma Klein also.
Very well, very well, very well.
Together they represented Mr.
Great, great. Well, the Blue Devils were well represented today, well represented. Thank you so much to the court appointed. Again, we rely so much on the services of lawyers like yourselves who come here, and those who soon will be lawyers. They come here and argue and help us with these great cases, these tough issues. Thank you so much. Thank you, Professor. And also, Nunley, we also recognize your able representation as well. We'll come down. We're going to come down to Greek Council, and then first we're going to ask the clerk to do a brief recess for us. Thank you.
This honorable court will take a brief recess. Fourth Circuit.
You may be seated. Mr. Brandt,
Yes, sir.
you may approach.
Good morning, good morning, Your Honors. Robert Brandt. I wish I could introduce myself as a 3L, but I haven't been a 3L in about 25 years. I'm just
There are three L's your age and who are in law school.
I am a suburban dad and a full-time bankruptcy attorney. My client is Mr. Cook, the debtor in this case. As coincidence would have it, that is also Mr. Cook, but that is a distinguished attorney. That is not Mr. Cook, my client. They just share the last name. So the posture of the case, the way I see it, is as follows. This is a Chapter 13 case, and I say this semi in jest, where the goal of the Chapter 13 debtor is to pay as little as humanly possible within the bounds of the law. And then you have the sheriff's office, that would be the Chapter 13 trustee, whose job is to squeeze as much money out of you as humanly and legally possible.
Before you get started too far, can you tell us what's the current status of the plan of your client's adherence and how many more payments remain?
Yes, regretfully, there are only, I believe, 3 months left in the plan.
And so the case could become actually moot, Article 3 moot, not just equitably moot.
That is correct, Your Honor, yes.
Thank you.
Yes.
I'm glad you're an expert on bankruptcy law, because I got some questions for you on this procedure here. But I
Okay.
do agree the question of whether the equitable relief should be something applied to Chapter 13. But this is an interesting case. The first plan submitted, your client submitted, because is that the way it works? You have to submit one when you want one. So you submitted one, I guess total is like $7,000 or so.
Yes, Your Honor.
The court then, or at least the judge then says, no, there's some problems here because you got a $98,000 profit you made off the house. We don't know what happened. You call these gifts that were made to your children and your father. So comes back and corrects that and says those are loans and all that sort of thing. But then a second plan is submitted. And so the question, at least from a bankruptcy perspective, if you submit a first plan and that's the debtor that's doing it, and then there's a second plan the debtor didn't support. The basis for submitting a plan is he limited to submit plans that he thinks or believes he can do?
Yes, I would answer that by saying it's essentially you put your best foot forward and you present your paper to your high school teacher, and she either accepts it and says, very good, plan is confirmed, whatever it is, $400 a month, or the court says, no, you got it wrong. I don't believe this or that is correct, which almost always means
But you
you
get
need.
my, the point of, the thing I want you to reach is, well, I don't understand, you got plan 1, 2, 3, and 4.
Yes, sir.
He keeps going up till he finally gets to $20,000. Daddy owes is $333,000, but it's $20,000 he's gonna pay back on this by the time you plan. Let's take plan 4. He submits it, same basis. This is something he believes he can pay, but he says you should have taken 1.
Yes.
The lower amount.
Yes.
But from a creditor perspective, you ought to be paying the best you can do under the circumstance. It seems to me that, creditors are entitled, you're entitled to relief, but you're not entitled to pay zero. So you could put a plan and say 0 or $5, but if it ultimately you submit a plan that says $20,000, I'm not following why you, and here's the kicker. You didn't ask to stay anything.
Mm-hmm.
You didn't ask to stay the first plan. It says, okay, this is what I can do. I suppose, and here's the question. Could a debtor refuse to submit a second plan?
So I think there were 3 questions there.
Now answer that question, because that's intriguing to me.
Yes, but the ramifications are the case gets dismissed. So the court says.
So then he appeals from the failure to accept the first plan?
Except that the Supreme Court of the United States said, nope, we're not going to do that anymore. For years, the circuits were battling anyway, and then it made it up to the Supreme Court, and the Supreme Court says,
So he has to submit a second plan.
you have to submit a second plan, you have to have a confirmed plan.
So if you submit a second plan, that second plan, if it's 7,000, what was it? The second one went to how much?
Honestly.
Well, let's say
200
20,000. Let's say up to 20, because it's $70,000 doesn't seem like a lot to me for $330,000. So most people walk away and say, hallelujah, instead of coming to appeal. If I could pay you $20,000 for a $333,000 debt, I would not be standing in the Fourth Circuit for some reason. I'm telling you, that's just my personal thing, because that's what I'm trying to make sense out of it.
I could answer that. I understand.
I mean, I could get it if you ultimately up paying $150,000, but $20,000. But I got that. But my question is, when he submits this fourth plan, and he's obligated to do so, he hasn't asked the court to stay the first one. The fourth plan, he's telling the court, I can do this within the parameters. Because I could have gone from, was he required from 7,000? Could he have gone to 7,500 or 8,000?
If I could try to answer that.
Yeah, give me a shot at this.
So I think that the elephant in the room question is, why is your client being so greedy, or?
No, that's not my question. I got that. I got you why your client's greedy. He doesn't want to pay all that. But that's not the issue I'm confronting. I'm confronting what is the effect of the second plan? What is the basis? Because do you get to submit a plan and then object to what you submitted? Is something you do? Can you submit a first plan and then say, I object to my first plan?
No.
Can you object to the second plan?
Yes. So
you can object to the second plan because you think the first plan was better.
Oh, absolutely. Yes. Absolutely.
But you don't ask the court to stay anything.
Right. So yes, in reading the decision of the Supreme Court of the United States and other case law that followed since that monumental decision, yes, there are certainly judges that have said, in order to make the record perfectly clear, we want debtor's counsel to go through the highly unusual step of objecting to his own plan, which is bizarre, because 99% of the time the objections come from the trustee or from...
It doesn't seem to make sense, does it?
Right.
I mean, you submit something and say, I can pay this, but I object to me paying what I can pay.
Yes. I object to this amount.
You see why this is a bad case for equitable relief to come in? You see, this is, of all the cases, I don't know if this is a good case. I mean, when I think about the equities of what's going on here, and maybe we shouldn't consider the differential. Again, you're saying that the first one should be accepted, I guess, as a matter of law.
Yes.
But that's going to the merits of this.
Right.
It's going to the merits of
Right.
it. And I don't know if we need to get to the merits of it if we say you can't. You know, it gets there. And we could go there, but it's, anyway, I mean, this is an interesting bankruptcy case to bring in this posture here. But maybe I'll let you go ahead and argue the case.
In my minute and a half, and I heard common sense and speak plainly, what this whole case is, if I could take off my lawyer hat, you did me wrong. You should have approved the first plan, $200 a month. Not because I said so, because Congress says so. Because Congress says my VA disability money, and that's where, hey, you've got this extra money, VA disability money, and Congress says you don't have to turn it over.
And if all we had was you did me wrong, that's one thing. But if I found out you got a $98,000 profit on a house over there, and I don't know what you did with it, and then I know you gave money to your children, and you say they were gifts, and then you later change to say they loans, that's a little bit more than you did me wrong.
Your Honor, respectfully.
Sounds like you're doing the creditors wrong. That's really what it sounds like. The creditors got done wrong on here somewhere.
In my 37 seconds, respectfully,
it just seems like a lot of audacity to me, but that's just my perspective.
Right. The audacity was a lot of sizzle, a lot of language that seemed colorful, right? Hey, you did this?
No,
You did-
I'm not giving colorful thing, I'm giving facts.
Right.
There's nothing colorful about $98,000 on a house, nothing colorful about the tens of thousands of dollars you gave to, as you say, paid back loans and $5,000 to dad. There's nothing colorful about that, that's facts. I mean, color is the case. The case is colorful, yeah, I agree with that.
Yes, Your Honor. I think my time is up.
Yes,
Thank you.
Ms. Grant, Ms. Cook.
I think Amicus goes next, yeah.
Good morning, judges of the Fourth Circuit, and may it please the court. My name is Richard Cook. I represent Amici Curiae, the National Association of Consumer Bankruptcy Attorneys, and the National Consumer Bankruptcy Rights Center. We are involved in this case for the singular reason because equitable mootness was invoked by the district court in this case. The underlying merits of the appeal, we are not taking a position, and we'd concede that we're not here because of that. We're not
I
touching
grant
on
you
it.
that. I'm not gonna give you the same question. Yours is a legal argument that it's interesting. It's a strong legal argument, I think, because these are normally in cases, Chapter 11 and some other type of, much bigger type situations. It's the first time we're dealing with it in the Chapter 13 venue. But, so that was a different, maybe some of it would come up with me, but I'm gonna leave it alone. And let
Well, I'll try and answer some of the questions you did bring up, but talking about equitable mootness, it's a judicially created doctrine that was created by the Ninth Circuit in 1981. And it was in response to a massive Chapter 11 case that transferred multiple pieces of real estate. And the belief with equitable mootness is, well, if we reverse the confirmation of that plan, we're going to be undoing all of these transactions that have closed. And these were third parties, people that weren't parties in the bankruptcy case. It's not fair to them. The bankruptcy rules at that time, it was Bankruptcy Rule 805. It's now Bankruptcy Rule 8007. It's additionally codified at 11 U.S.C. 363M. If you do not get a stay pending appeal of a transfer of property, then that can statutorily moot in appeal. And so that's what this was born from, very complex Chapter 11 cases, because as you pointed out, Judge Wynn, there is no circuit that is extended equitable mootness to a Chapter 13 case.
But couldn't there,
Go ahead,
sorry,
Judge.
just couldn't there be a Chapter 13 bankruptcy that was complex and equitable mootness could be applied?
100%, and we're not trying to say wholesale you can't apply it in a 13
So
case,
you're
but
not asking for a categorical rule?
it would need to be a conveyance of property to like a third party, because in a Chapter 13 plan, you do have the ability to transfer property to a third party. That ability exists. Didn't happen here. When this debtor filed for bankruptcy protection, there was no real estate.
So you're suggesting that on these facts, equitable mootness was inappropriate, not that there should be a categorical distinction between Chapter 11 and Chapter 13?
Correct. I think when you do involve the rights of third parties, which here we don't have that. We just have 4 unsecured creditors totaling $116,000 receiving parts of that, $20,000 that's getting paid in. Those are folks who voluntarily filed proofs of claim with the bankruptcy court, submitted to the bankruptcy court's jurisdiction. The 13 trustee is basically like a fiduciary on behalf of those unsecured creditors, looking out for them. So we don't have those same concerns.
And what's our standard of review?
Standard of review, there isn't, as we point out, this court has not adopted a standard of, thank you so much for asking that, Judge Berner. This court has not adopted a standard of review for looking at questions of equitable mootness. There is a conflict between the circuits as to the appropriate standard of review. It is our position it should be de novo, and there's 3 reasons for that. First, equitable mootness is only raised on appeal for the first time. This is not an issue that bankruptcy courts address head on. And so because it's an appellate court hearing it for the first time, we don't think that there's the same implications, as far as like reviewing facts, because that's the second part is there's not really factual determinations that we need to rely upon in this
Right, but it's an
analysis.
equitable doctrine, and generally when district courts act within their equitable power, we review for abuse of discretion.
I mean, I guess, but I guess that
Well, the circuit court has held that. There's another circuit court that's held that.
Right, and like I said, the courts have gone both ways. It's just one of those, we think because it's first impression, and the admonishment, I mean, we even have, I think, subsequent to those decisions, we've had the Moac Mall decision from the U.S. Supreme Court, which discourages what they call like these types of mootness, which they mean equitable mootness. I think in light of that, you really want courts to hear cases on the merits, because going to your earlier point, Judge Berner, it's like, well, what about Article 3 mootness if there's just 3 months left in the plan? We are in this
And he's
procedural.
only asking for prospective relief.
Well, we're in this procedural posture.
So when you're only asking for prospective relief, he says 3 months, I don't know how many months. I mean, I'd have already paid this month, might have 2 months. You're talking 2 months of payment, and then this thing is moot. Is that right? Unless there's some other type of relief.
There is some other type of relief, and if you look at 11 U.S.C. 502J, so it's the ability to kind of revisit claims. The trustee holds the right to claw monies back from creditors who were overpaid.
He's only asking for prospective relief.
I understand that. Well, it's a right the trustee holds. So I know what the debtor's asking for. The trustee holds the right
And
to
the
where.
trustee is a party to this too. It brought this, is in trying to get them to go back and give him relief?
I don't think the trustee's asking for that, but I guess what I'm saying is there is a possibility of relief here, of money being refunded
Where
back
would
to
it
the
come
debtor.
from?
It would come from the creditors who were paid under the plan.
They would give money back.
So 502J of the code specifically contemplates that if a creditor was overpaid on its proof of claim, the trustee holds the right to be able to get that
And
money
you
back.
think it's an incident, the trustee is gonna go and ask those people to give money back for something that he's only asking for prospective relief?
You know, I don't, the trustee is here, he can speak
You
to.
don't credibly believe that.
Well, it's the district court that put us in this position, though. Like, if they heard the merits of this case the first time, it wouldn't have delayed the case by almost 2 years. And so it's the quagmire created by the district court itself that has put us in this position. Because
Is it typical to ask for a stay when you go from a first to a second plan?
So the short answer
In
is.
other words, can you ask for a stay?
Can you? Yes. Do you? No. And there's a couple reasons. One, cost. It's just, you're talking about consumer attorneys and having them have competent counsel to seek stays in the bankruptcy court, the district court. But this court, so we talked about the Supreme Court case.
What does it cost? I mean, you just asked, I want this to be stayed.
Well, I guess it's more for the attorneys, you know.
The attorney puts one little motion in there, a couple of paragraphs says, we asked that this would be stayed. Your determination that the first plan was denied, we ask you stay the enforcement of it.
I think it'd be slightly more
What's
complex.
expensive about that?
Well, I guess, let me get to the second point then of.
No, I want to hear that answer, because I like bankruptcy law, and I'm trying to figure out.
Well,
you say it's
well,
expensive, because bankruptcy law is interesting. There's a lot of money floating around here. I want to know the answer of what makes that expensive to simply ask for this to be stayed.
There's the time aspect. You have to do it within that certain 14-day window. You also need to have competent counsel that knows the various elements. I guess I take it as being a little
All
more
you're
nuanced.
asking for is to be stayed. You've been denied. And all you want to do is say, I mean, can't you just say, I want that stayed? I'm going to submit my new plan, but I'm doing it objecting to the fact I have to do it, and I want you to stay that. Otherwise, when you submit the new plan, it's like, well, okay, I'm going to go back and revisit it, and this is the best I can do here.
A couple of points to that. So Bullard versus Blue Hills Bank first tells us that interlocutory appeal, or the denial of confirmation of a plan, is interlocutory. And so you talk about you could get a stay. What this court has done, and we saw this in Trantham versus Tate from the Fourth Circuit here 2 years ago, that is a case where you talked about the debtor then has to file a plan that, what I call an offending plan, a plan that it disagrees with. The debtor then objects to its own plan to then have a confirmation order, which is now a final order.
In other words, a debtor can file a plan that I guess essentially says, I can't do, or is that it? Or what does it mean? Or it doesn't meet the criteria for me doing this, but I'm gonna do it because you're forcing me to give something else. Is that what you're saying?
Essentially, they're filing a plan that they think the court wants and would confirm, but they are objecting to
But
having
it seems to me, and I'll leave it away, if you were doing that, is there some requirement that you have to go up considerably higher than the first plan? In other words, could it have gone from 7,000 to 7,500?
I mean, it's possible. It's generally a numbers game based on, you know, for example, you have to satisfy the liquidation test. What would creditors get in a hypothetical 7? And that's generally a number that is is somewhat readily ascertainable. You would look at what could be recovered, certain expenses from it, so that there's a lot of times, yes, a number. Like, there's a number that you probably need to hit here because these transfers could have been avoided and recovered by a 7 trustee, so that's why these additional monies need to be paid in. But
Is there any instance where if you do not submit a plan that's acceptable, at some point in time, the court or the trustee or someone can submit a plan?
no, debtor is the
That is
exclusive,
the only one who can submit a plan.
debtor is the only one who can file a plan.
And
They have
they
that.
can't change the plan or do anything with it. You either got to take what he says or nothing.
Well, the way the court works is it's kind of a thumbs up or thumbs down with the
Yes.
court, to where the
Like a
court,
baseball commissioner.
the
Or
court can
referee.
basically say, if you would have done a few things, I would have confirmed it, but the court can't come in, redline it, and
Right.
based on those red lines, now confirm the plan. That's not how it works. They can send it back.
And
But
in terms of our review, if we were to reach the bankruptcy court's finding that the plan was not proposed in good faith, we review that for clear error.
I believe that's correct, Your Honor.
So that's a highly deferential standard.
I believe so.
And why was that a clearly erroneous finding?
We're not taking a position on like the ultimate merit. We're here based solely on equitable mootness.
But if we agree with you on equitable mootness, then the merits are still at issue.
Well, I guess my position is, if you agree on equitable mootness, I think the district court needs to be the first court of review, because the
There
district
are
court.
3 months left in the plan.
Well, I guess I'll speak bluntly. If this court holds that equitable mootness was improper by the district court, but still,
It seems to be exacerbating the very problem that you're pointing to, that the equitable mootness caused delay. So if we were to find equitable mootness was improper and not reach the merits when we have the record before us, certainly we could allow for it to be reviewed, and sometimes we say we're a court of review and not first view, but here, we're facing a 3-month to actual Article 3 mootness issue.
I think if the opinion of this court was clear that equitable mootness was improper, should not have been done, but still upholds the ultimate, it still ultimately affirms the bankruptcy court, it's the position of amici, like, we're fine with that. We are
You
here.
don't have a dog in that fight. Your dog is you just don't want us to say equitable mootness applies as Chapter 13. Whatever happens in this case, that debtor, he's on his own then. That's all you're here for.
Wait, correct, Your Honor, because it will harm debtors across this circuit. I mean, this case has ramifications far beyond this one. Because as Ed is pointing out, we cite it in the brief and all the criticism of equitable mootness. There is a race in Chapter 11 to confirm plans and push monies out the door and complete transactions so the debtors can then use equitable mootness as the
So if it
shield.
goes moot, then you still win, because if ultimately the 3 months it goes moot, we haven't said a word about it. You're okay with that too, aren't you? Or
Well-
do you want us to say something? Are you sure you want us to say something? Do you want us to say something if there's an opportunity to dismiss this case as moot?
We would like this court to say equitable mootness was inappropriately invoked by the district court.
And no court in the nation has gone there yet, right?
Not in a Chapter 13 case.
Right. And you want us to now opine on it and risk the chance that we could go the other way, when you don't have to take that if it's moot. You sure?
I mean, yes. I mean, yes, Your Honor, because, well, also, think about it from this perspective then. If it's upheld, this will
And
become.
then even it's only gonna apply to Fourth Circuit.
Well, well, we're a national organization. It would be a shield now used by debtors, because this will cut both ways. To where when a debtor confirms a plan that now the trustee and creditors have objected to and have issues with, if they did not seek a stay pending appeal, then debtors will be able to use this as a cudgel to cut off those rights on appeal, which is exactly why all the other circuits have had problems with the way equitable mootness is invoked in Chapter 11 cases. We don't think it needs to now start infecting Chapter 13 cases.
All right.
All right?
Thank you, Judge.
Thank you, Mr. Cook.
Appreciate it.
Mr. Gorman? Ooh, be careful.
Good morning, Your Honors. I'm Thomas Gorman. I'm identified on the caption as just Chapter 13 trustee, but my name is Thomas Gorman, as I said. The issue here is the district court's order dismissing debtor's appeal on the grounds that the matter had become equitably moot by virtue of the debtor's failure to seek a stay pending appeal. And Your Honor's asked a lot of questions. One I don't think was asked is, why didn't the debtor use Bankruptcy Rule 8007 at either of the two junctures he could have and seek an appeal, a stay pending appeal, and then we wouldn't be here. But there's a rule for this. It wasn't invoked or complied with, and here we are. The matter is now moot. It was moot in December 24 when Judge Knockoff issued his ruling. It's now mooter today by virtue of the passage of time. Debtors' counsel's appellant's representations that the plan is now in its 33rd month of its 36 terms.
When was the first plan issued? Just remind me of that. When did he submit the first plan?
Within a month of the
And then
petition.
how long was it before finally the bankruptcy court said, okay, Plan 4 is good?
May I have a moment?
Yes, just give me a ballpark figure.
I can give you, the petition in this case was filed May of 23. The plan was confirmed in February of 24. So it was roughly a 9-month process.
And so the process allows, when you put a plan in place, for them to begin to make the payments.
Yes.
At that point.
It's required. They have to start the payments.
And I've been asked about stay or something like that. If you want to go back to the first, could a stay been asked
Yes.
of number 4?
Yes. Yes.
And is it usual for that to be asked for?
Yes and no. Let me give you, there were two junctures a stay could have been asked for. The first one was a denial of confirmation of the first plan. Debtor would have had to seek an interlocutory appeal, because that is an interlocutory order, and a stay pending appeal. Debtor did neither. Then later, there was a second opportunity. When the fourth plan was confirmed, no money goes out till the plan is confirmed. So at that point, the debtor had a second opportunity to ask for a stay pending appeal and could have said, Judge, let the trustee disperse the $200 a month. I agree I should have been paying. Make him hold back the extra $425 till I can get a ruling from a higher court on whether that first plan should have
But
been.
there's no requirement that he seek a stay. It's
Pardon?
simply, there's no requirement that a stay be sought.
No, none,
And
but
you opened by saying the district court ruled on the basis that the applicant failed to seek a stay, but that's just one of 4
Yes,
factors.
yes.
And the district court, let me finish, and the district court found that all 4 factors weigh in favor of equitable mootness, not simply that factor. And it just strikes me that your argument that the failure to seek a stay necessarily means equitable mootness is appropriate, de facto creates a rule that the debtor must seek a stay. Otherwise, equitable mootness will be imposed upon him.
Allow me to make this one point. The reason the stay is important here isn't the confirmation, but the money going out to the creditors. Under the statute, I'm required to, absent a stay, disperse to creditors. That's what makes this moot. Counsel for the amici argues that they voluntarily filed claims, those creditors. That's true, but they weren't voluntarily. The debtor filed a voluntary position. The creditors had to file proofs of claim to get paid. Your Honor mentioned a $300,000 number. Counsel mentioned a $100,000 number. The difference is only some creditors file proofs of claim. Those are the only ones who get paid. So it wasn't a voluntary process by the creditors to participate. They had no choice or the debts get discharged. Having filed a claim, no stay being issued, me holding money, confirmed plan, the money has gone out the door. Of the $20,000 the debtor has paid in, $18,000, I'm using round numbers, has been dispersed. That's what made this matter moot then. Money's
But
been.
the bankruptcy code doesn't say if a bunch of money's already been paid and there's not a lot left to be paid, then there's no right of appeal.
No,
This
it's the
is a
doctrine of
judge-made
equitable-
doctrine.
It's the doctrine of equitable mootness that says that, nothing in the code.
Right. And are there cases where this doctrine is applied? Are there appellate cases where this doctrine has been applied in the context of basically fairly simple bankruptcy plans, like this one?
Not a lot, no published opinions.
There are no appellate opinions where that's been applied. And is it common for district courts to apply the equitable mootness in the context of these
It's-
small dollar bankruptcies?
It's not common for them to go up to it on appeal in the first instance.
Is it common for district courts to apply the doctrine?
There's this one, there's 2 more pending in the district court right now involving the same counsel. Other than that, I have no experiences with this issue. It's come up 3 times in the 40 years I've been practicing.
The answer is no.
No,
It's not coming.
no. These cases usually die at the bankruptcy court level. Court rules thumbs up, thumbs down. Debtor files the next plan, and eventually you come to a number, and it's happened here, the debtor performs, and the case gets closed out. But my sole point is, with 33 out of 36 months, the money's down out the door, the case is moot, and the debtor had the option, not the requirement, the option of
Is
seeking.
it only 3 months left on the payment?
Yes, yes,
It's
yes,
3
sir.
months, and how much is it being paid per month?
$625, another $1,875 he's done, the
And
plan
the
term.
differential between the 6 and the first plan would have been what per month?
It was $200 a month was the first plan. The last plan included $200 a month up to the point of confirmation and $625 thereafter.
So we're talking about amount in dispute would be, if you said the first plan would have gone, because he's only asking for prospective relief.
Right.
I understand, the expert tells me, you can go back and make creditors give money in retrospect, even though they only ask for prospective.
I could theoretically sue the
Even though it's
credit-
been confirmed and these people been receiving money, just like getting a social security check. You know, if you get one that's over, they'll make you go back and give it back. So you got the same situation here.
I suppose theoretically, I could sue them for disgorgement if the courts were to reverse and remand.
Any
But-
chance of that?
But again, had the debtor filed a motion for stay pending appeal, none of that we wouldn't be talking about this. So there's a rule there that allows this to be prevented.
Mr. Gorman,
Yes.
you help me with this. The old saying is that you don't bid against yourself. Well, it seemed to me, when they made the first offer and that was refused or denied, couldn't they just, as they say, stand pat? Then the court would have then suggested what the amount should be?
No.
What happened?
Counsel had it right. When confirmation is denied, debtor has the option of either filing a new plan to try to meet the court's concerns or appealing that plan on an interlocutory basis and seeking a stay.
So you're required to keep on going up?
No, you can appeal it.
I mean, if you don't appeal,
Yes, yes.
The only option is appeal or keep going up.
But it's not always denial confirmation on dollar amounts. Sometimes there's a feasibility issue. The debtor can come back and say, I have a second job now. You denied confirmation
Oh, I see.
last time.
Change of circumstances.
Yes,
Okay.
yes. But you have to file, and Chapter 13 moves pretty quick. You have a narrow window of time when confirmation is denied to file a new plan, convert your case to another chapter, appeal the confirmation. You have to do something.
Yeah.
Unlike Chapter 11, they can't lie fallow for any period of
So
time.
that procedure really sort of helps, the object is somewhat is trying to make sure this case doesn't get to the point of equitable mootness by trying to work it until it finds that sweet spot
Yes.
that we
Yes.
can agree on. But if you don't avail yourself of those things you talked about, then you run the risk that it ripens into the equitable mootness.
Ultimately, your case would get dismissed and you didn't get the benefit of the bankruptcy.
Right, right.
And as I said, I started to say, I think, in their brief, the appellant asked the court at page 14 for specifically prospective relief. What the debtors asked for is that the court, going forward, allow him to pay the $200 a month amount he wished for. The debtor is not asking for retroactive relief, disgorgement of money. The debtor at page 14 has specifically said, I'd like this court, sitting in de novo review, to modify my plan going forward for whatever plan term is left, to put me down at that $200 a month amount I felt I should have been at the beginning. So the debtor now is asking this court for roughly, I guess, $1,200.
What is the representation, at least, it seems to me that a debtor submits a plan, there has to be something there that they do so either in, I guess, good faith is a strong word, but some belief I can pay this.
Yes.
I mean,
Yes.
we got the law, but this is really about money. I mean, bankruptcy is about money. If you talk about the differential money, I called up the little figures, the big figures, and people blew that off like it was no big deal, but it's all about money. And a difference of paying $600 or $200 per month. But I will pay the $600 all the way up until the time the appeal court could rule in my favor. Then I'll pay the $200 for the rest of the time, which is basically $200 or $300 for the next 3 months. It's, sort of I mean, we have a lot of cases up here, and this is must be about law. We don't spend a lot of time talking about $600. It costs $600 for you guys to come in this courtroom. Makes no sense. I mean, I got the bankruptcy expert on it, on the equitable the equitable type relief. I got that. That's a big issue in this case here. But the actual facts of it, it's almost like, why would you bring this case?
I didn't, I'm an appellee. I mean, if Your Honor's pointing out that the cost of my hotel, gas, and food getting down here is more than the $1,200 in dispute, you are correct. That's why these small dollar cases don't get here very often. In the light most favorable to the other side, they can be lauded if they consider this an important issue for spending time on it. We all go to law school, saying
Well,
we're
the
not in this.
issue is important. The ultimate issue in this case of whether the equitable relief is available is very important. I'm just saying, but it's the motivation bringing in a case of this sort. But what is disturbing me still is, which I just don't understand, this bankruptcy law, and that's what I'm trying to get clarity on it, is when you submit that second, third, and fourth plan, what are you submitting? I mean, and why would you submit, if it's money, why would you submit something that you would feel so strong about that you're gonna appeal it?
I don't know, but what happened?
Because couldn't you just, I mean, what would happen if you come back and says, okay, 7,000, I can't do, but I can do 7,100? What happens then?
Then the bankruptcy court considers that plan, denies confirmation or not, and if the court felt that your $100 increase was so incremental as to be insulting, the bankruptcy court might deny you leave to file another plan. But if
Which means that's the end of it.
subject to
And
your
then
appeal
you gotta,
rights.
then you
Yes.
can appeal, that's not interlocutory.
Yes, sir. Yes, sir.
But the debtor doesn't want to risk that, because if you don't get it, because then that's a question of whether you can file bankruptcy, and the end result of that, you're gonna have $333,000 you owe, and you're not gonna get relief.
Right.
Okay.
So I understand that you're arguing in the alternative that even if we find equitable mootness not appropriately applied here, that we should reach the merits and affirm on the merits. Is that right?
No, ma'am. I think all that's here is the issue of the equitable mootness. That was the sole rule of the district court's opinion, but I've been listening, I've heard the court say that sometimes you look beyond that for efficiency. But procedurally, I think what's before the court today is solely the issue of whether the district court erred in applying the doctrine of equitable mootness in the facts
And the
of
district
this-
court, in applying that doctrine, didn't reach the merits.
No, ma'am, it did not. Said it didn't need to because the matter was moot.
But really, the merits were really two issues. There was the issue of the bad faith, and then there was the issue of the liquidation test. Isn't
They
that
go
right?
hand in hand, because the transfers that went out, a seven trustee could bring them back. That was part of the liquidation test. So good faith was making the transfers in the first instance, and the liquidation test is what would have been available for seven in chapters if a trustee had recovered those preferential or fraudulent transfers and brought it in.
And
the
so in
bankrupt-
reaching the merits, the district court, or whichever court was reaching the merits, would have to reach both? The good faith issue and the liquidation test issue?
Yes, the way I see it, if the court were to remand it, the district court would then remand it to the bankruptcy court for further findings. Or actually, maybe I misspoke, maybe the record at the first hearing was sufficient that the district court to look at that de novo and say the bankruptcy court erred or did not err based on the evidence before it.
And 3 months will have passed by the time they get to it, and this will be moot before then.
The way the calendar looks.
It's gonna be moot either way. There's no way they're gonna hear this case. Or do they hear that case?
That's
I
my
mean,
thing, but
if we
again,
made a decision,
I can't
which it
enforce
takes
it.
us some time to issue an opinion on it, could be a month, could be 2 months. We send it back, 3 months is gone. What happens then when it goes? We sending them a case that's gonna be moot, right?
Yes, but Your Honor,
Well, in
one.
your brief, I mean, half your brief,
What's that?
really half your brief argues that the bankruptcy court did not err. So you're,
Because the other side argued it in their brief, I had to be responsive to that. But I think procedurally, all the district court ruled on was the equitable mootness. But if I can make one point before I run out of time, again, Your Honor talks about the frustration of what happens this, what happens that. That's all avoidable. If a stay pending appeal had been sought, we wouldn't be at the 33-month of an almost completed plan. There's a rule there, it wasn't used. So I don't know if the court should be doing backflips, trying to No wrong was done here. The court shouldn't be twisting pretzels trying to make it right. The debtor had 2 opportunities to seek a stay pending appeal, didn't. The case is now effectively concluded. Creditors have received their monies. That's unlikely to come back. I think the district court ruling should be affirmed. Thank you. If you have any other questions.
Thank you, counsel. All right.
One last question. Before you sit, one last question, because it's kind of something, I don't want them to be blindsided. You know, this court, sometimes we'll decide something, said, assuming without argument that applies, and we send it back. We'll send a case going to be moot, and we won't decide that issue. I just don't understand this case, the procedural posture of it, but, I mean, that can be done. I mean, this court could very well say, assuming for the sake of argument that it does not apply, we send it back for the district court to consider it. And then the district, or for the bankruptcy court to consider it. They go back, and of course, in a normal course thing, they just said it, and it come back, and then we would get it. But by the time it goes back there and it gets considered, this is done, because it's only prospective relief that's being sought. If he was seeking relief for the whole thing, it would be different. But anyway.
I don't get it either, and the only argument I heard is the academic issue of getting a ruling on the applicability of equitable mootness in 13. That
We don't do advisory opinions.
Yeah, that would be my thinking. But any other questions?
Thank you, counsel.
Thank you.
All right, we'll ask the court to adjourn the court. Oh, no, we got one more. Oh, it was a long day, isn't it? We do have one more, don't we? Thank you, counsel. We'll come down and greet you, and then we'll proceed to our final case for the afternoon.
Patience and care.
You may be seated. Thank you. Mr. Hawkins, when you're ready.
Yes, Your Honor. Good morning, Your Honors, and may it please the court. I'm Josh Hawkins here on behalf of appellant Dawn Lusk, who's here today. She was injured when she went to the Salem, South Carolina post office by a post office employee. We filed claims under Bivens and the Federal Tort Claims Act. Our case was dismissed, and I think the main issue before the court today is the Federal Tort Claims Act, so that's primarily what I'll speak to. The questions before the court—
You just don't have a remedy. I've been studying your case back and forth, and it's an odd situation. You got an assault and battery that the Federal Tort Claims Act says you don't get anything, and then you got the Westfall Act that can't go to state court. I can't figure out how you got a remedy. I've been studying this instance that I did Federal Tort Claims Act back when I was in the Navy, and it was an interesting case to me. You can take every fact your client says is true. She goes in there and she gets beat up by one of the postal workers there. But everything I'm seeing here, if you can't make a Bivens claim, and that is a long shot because you got to go due process, substantive due process. I don't know where you're going to get there. But anyway, I wanted you to hear that up front so that you can have that in the context. Maybe you can help to get us there. But I feel for you because I can't figure out in the world why your client does not have a remedy, not in state or federal court, in light of the existing law.
Your Honor, that is exactly, and I'm glad Your Honor brought that up because that is exactly what our jurisprudence has said. If there's not a remedy, in one of these situations where there's not a remedy, we've got to find one. Chief Justice Marshall said that in 1803 in Marbury, and I didn't think I'd ever have to actually use Marbury, but I had to go back and read it because of this case. The Bivens cases, and Your Honor pointed out that that's an extraordinarily uphill battle, and I get that. I don't think it should be, because I think if a federal agent violates someone's constitutional
Well, the
rights.
Supreme Court has killed us on that,
I-
dude,
in the
and
past
what we
12
got
times.
here, I think, that would be hard to get. Maybe,
Right.
if my colleagues can figure it out, I'd go with it, but that's a hard one.
But-
So then you're left with the Federal Tort Claims Act.
Right. Well,
That's done.
and even with Egbert and Rodriguez, even with the rulings that were in those cases, they look back to Carlson and Davis and Bivens, and the sentiment is always the same. If there's not a remedy under one avenue, you should find a remedy in some avenue. And so I think, Your Honor, there is a way to get there. Number one, I don't think any court has grappled with whether or not this postal worker, Peppers, had the mental requisite to form a battery. And the cases that
What was that, say that statement, it had the requisite to do what?
the mental requisite, in other words, the mental element of battery. I don't think any case has looked at, is there even a battery? Because if she subjectively was so unreasonable, and it appears that she was, because most or all this is uncontested. If she was so unreasonable that she thought that he had to use this level of force, or any force at all on a customer, if she subjectively believed that, no matter how unreasonable, then there's not a battery. My colleague cites to Talbert.
Then what is it, negligence? Or
Well,
something that fits with?
It would still be negligence or recklessness, because you still have duties there and you still have a breach. But if you don't have the mental requisite to complete the battery, you don't have a battery. That's what the second restatement of tort says. And Talbert tells us when we did this analysis, that's where we have to look. My colleague cites to Talbert, rightfully so. When we look at the nature of the tort, we have to look to the restatement. That's what Talbot tells us. That's, Billups.
Let me, and I'm gonna turn this loose, but you're saying that April Peppers didn't have the mental capacity to commit a battery?
We've never gotten to ask her. We didn't get to do discovery.
Now, certainly in ways she describes, she sounds like she's something else.
Well,
But I mean, we have criminals that come through here all the time that same kind of person. I don't know what you're gonna pull up. I've never seen that where a battery has not been, I mean, in theory, it's there, but
right.
I hadn't seen a criminal case where something like this, where you get off because you don't have the mental capacity to commit a battery, you did something else. Under these facts, she came from behind this.
Right.
The supervisor opens the door.
Right.
She goes in and beats this woman up.
Yeah. Caused dental injuries, knocked her to the ground, kicked her, violated her.
And she has a history.
Yes. Yes. Violated my client's constitutional rights, the right to bodily integrity, excessive force, all that. And importantly, to Your Honor's point, Ms. Peppers was never prosecuted criminally. So there's no criminal battery. She was not terminated from her job. There's a video of this that we never got.
She could be prosecuted criminally.
She probably should have been.
Could be. I'm not sure the statute would run on that. I think you can't be.
We don't have.
Yeah,
it.
well, she could be. And if you don't think the prosecutor does it, most states got a way in which you can do it yourself. But I'm not sure because you got the Attorney General, someone to agree to do it. But I don't see what keeps her from being criminally prosecuted for beating this woman
Right.
up. But that's not the issue in this case. This is a civil case.
Yes, Your Honor. I would say that we at a minimum should be able to go back, do discovery, and do some discovery on this mental requisite. And let me ask her, were you intended to act in defense of merchant or the property, which was the workplace, or yourself, and see what she says, because all of those are complete defenses to battery. That there wouldn't be a battery there. Now, if there is a battery, if the court tells us, as my colleague rightly points out, if it sounds in battery, if there's a battery anywhere in the mix, you got to look at that. Okay, well then that would put us in the proviso. And we don't argue a lot about the proviso in the complaint because we say she didn't have the mental requisite. But if she wants 2680H, she's got to take all the parts of 2680H, which include the proviso that you can proceed with an intentional tort against someone who has investigative authority. What United States Code says at 39 USC 603, I believe, is that any postal worker has this authority. That is different from 39 CFR, I think it's 233.1A, which says postal inspectors have certain authority. They can carry guns, make arrests.
Congress used specific language in the code. It says any postal worker. And if we look at the proviso, it doesn't just say law enforcement, it says law enforcement, or if you have an investigative ability or authority. And that's exactly what all postal workers have. And it's not just a little bit. They can search any car containing a package which has lately been to the post office. They can search offices, stores. They have a lot of investigative ability. And so, Your Honors, I don't think, we don't know that there is a battery, so at the minimum we should be able to do discovery on that. But if the government pushes us into 2680H, we have to look at the proviso, and we can proceed on a battery claim because Ms. Peppers and Mr. Merchant both have investigative authority. Now, we get into, at this juncture,
What did you allege in your complaint?
we alleged negligence and recklessness because we didn't want to get caught up on the 2680H exclusion. My colleague will say that even if you get by that, then you're foreclosed by 2680A, which, as the court knows, is a discretionary function. But there's no discretion to violate the Constitution. I mean, this court has said that in Medina, well, really every case, even Pornomo, where the plaintiff doesn't win, the court says, you can't violate guidelines or statutes or the Constitution. We describe constitutional violations, and the guidelines say that they can't engage in anything that's notoriously offensive or criminal, or it lists bullying and violence specifically.
So I guess what I've been sort of grappling with this, you know, during the week, we hear a lot of cases, so I can forget stuff whether the district court did it or not. Did you argue any of this before the district court or in your brief?
Well, Your Honor, as to that, we say that we don't have to argue about the proviso because we don't say we committed a battery. If they push us there, we say this is the operation of the law, that 603 says what it says about postal workers. But if the court needs a way to look at that anyway, some authority, the Medina court said it looked at a situation where the government hadn't raised one of the exceptions in 2680, and it said even though the government didn't raise that, we're going to look at it because it has to do with consent to be sued, and it has to do with sovereign immunity. And if all that didn't work, you could go back and get the authority to look at it from this court's case in Omar, which relied on Alano, and said if there's going to be a fundamental fairness, and I can't imagine a more fundamental unfairness than this, then we can use our discretion and we can look at something that wasn't raised. So that will be our response to that, Judge Wynn.
But I don't understand, Mr. Hawkins, obviously, you know, you deal in the battery, the language of, it cannot be something that arises from a battery.
Correct.
So in other words, you're trying to remove the battery. But under these facts, how do you remove the battery when, as you pled, she was using profanity, she meaning Peppers, as she came out of the gate? And then she then proceeded to pummel your client in a horrible, severe way. What's missing from the battery? And I know what just was judged. I understand that you didn't say that she didn't have the capacity, she didn't have the requisite state of mind for battery.
Yes.
Because she could have been defending herself, those kind of things. I mean, not capacity, but it's a requisite thing there. But how so when you noticed she was cursing as she went toward her and she then beat her up? Where's the disconnect from being a battery? Assault and battery.
I'm glad you asked that, Judge Gregory. I don't think it's any different if she was acting in defense of her workplace herself or Merchant, others. It would be no different than a man hears he's got his wife and his baby in his house and he hears a noise and he goes outside with a bat. He's going to use some cuss words. I would. And so the fact that he's cussing and carrying on or whatever don't mean that he is not defending his family.
Yep.
It's that subjective belief.
But the problem is, though, the context here is the lady is just making an inquiry about her mail. She said, look, I have a box here, and it's not enough in there. I know it should be more mail in there. Can somebody please help me? So it is unlike your hypo, where there's a threat to his family. You're absolutely right. You might be cursing more than that when you get put the Louisville Slugger on him. But here, on both ends, is nothing that would prevent this from being a battery in a sense, because your client didn't do anything wrong. I mean, she was just trying to be a customer, trying to get her mail. She comes out cursing, and she goes straight to pummeling her. What could possibly be missing from a battery, assault and battery?
The mental requisite to do it for an unjustified purpose, and we don't know what it was because we haven't gotten to ask her. We never got to take her deposition. This was dismissed at the motion to dismiss stage. And so we'd like to ask her. And if they want to then make a summary judgment motion, they can make that motion. But again, we think we get in the proviso. So we think we win either way. And I will say this, just because I'm getting a little short on time and I want to make this point.
Yeah, I know, yeah, go ahead.
Your Honors, as the court well knows, the Sheridan case sort of eroded Shearer in those other cases. And what Sheridan said is there are at least some contexts where there can be a battery in the mix and there can still be a recovery. Now, that sprang from an independent duty, of course, under either, I think it was Virginia law, maybe Maryland law, but either way, where you have an independent duty that has nothing to do with the battery itself, you can proceed. And so I think we have that here too, because Merchant undertook a duty when he goes around and he mocks, berates, whatever he does, he denies her medical help. Under our jurisprudence in South Carolina, the case of Steinke versus Department of License and Labor, you can't undertake and then act recklessly. So he goes around and he undertakes to interact with her, but he won't let her use the phone. She's on the floor with dental injuries, been punched and kicked and beat up. He won't let her do anything, grabs her by the ankles as if he's going to drag her, but then he doesn't. And then he won't let her make a call or call somebody for her.
But the facts are horrible. I agree with you on that. But I was wondering, and I guess the law, I looked at it too, it seems very tight on it, but it seems like to me, you could, with a straight face, whether you win or not, would say, well, she was not acting in the scope of her employment. She was working back there behind that desk, and she came from behind the desk out into the open public area, which is not her employment. You didn't make this argument, but I'm saying if she's not in the scope of employment, then Westfall is kind of out of the whole deal. You might get the state court on the thing, but you didn't argue at that point. I admit, I appreciate where you're going with this, that you want to discover to say that battery is not battery. That's probably a very uphill battle to win. I mean, any day of the week you can admit that, but you're making an argument. I got you.
Right,
You got to do this because you say, and this business about there's got to be a remedy. I don't know about that. I mean, certainly Bivens, I just don't think is available, and that would be the remedy you could get in federal type thing. You go with some type of constitutional right. Bivens just doesn't look like to me it's available. So it's put you in a conundrum here, but
it does.
I was wondering why you didn't at least broach the scope of employment. Is it that it's just that so much out of consideration that it's not even plausible?
Well, we challenged the Westfall certification. We didn't want the individuals dismissed, obviously, but when the government submitted that certification, Judge Coggins, he granted that, he substituted them in, and we said, okay, well, we'll proceed.
So you conceded it? Okay.
We'll proceed this way. My time is up. With the court, allow me to make one point about the Martin case of the Supreme Court.
You may.
Thank you, Your Honor. I just want to point out, because I think this is important for the analysis, that, courts have grappled with the interplay between subsection A and subsection H, and the Martin case that came out last year addressed a supremacy clause defense, and so it didn't really look at if you clear A, do you then have to clear H? But it did acknowledge that it's a problem. And so to the extent that that matters for the appeal, I just want to say I think we cleared both. In the Fifth Circuit, if we cleared the intentional act exclusion, we will be able to go forward. In the D.C. Circuit, we would have to clear both, and the 11th Circuit, of course, takes a completely different approach where they read the proviso into all the exceptions. That may be an issue, but I don't think the court has to reach that, because I think there's no discretion to violate the Constitution. I think there's not a battery, and if there is, I think we're in the proviso. So that's my argument, Your Honors. Does the court have any more questions?
Thank you. You have some time reserved.
Thank you.
Yeah. Ms. Mittal?
Good morning, Your Honors, or good afternoon. May it please the court, Urja Mittal for the government. As Your Honors have recognized, all of the tort claims in this case arise out of allegations of assault or battery. Those claims are barred by the enumerated torts exception in the Federal Tort Claims Act. This court has repeatedly held in cases like Billups,
That's the
Talbert.
end of this argument, isn't it? Because the assault and battery is an exception, can't go to state court because of the Westfall Act, scope of employment. My question to you is, I know scope of employment comes in the Westfall Act context, but in the Federal Tort Claims Act, does it apply in an instance in which one is not working within the scope of employment?
Your Honor, that's part of the Federal Tort Claims Act, but it's not an inquiry that the appellant has challenged here or that's in contention here.
In other words, if Ms. Peppers comes from behind this stand and then she's out of the scope of her employment, I'm not saying she is, because I think case law pretty much says she probably is, but if she's out of it, what the Federal Tort Claims Act, I guess it's the same thing. It's like assault and battery. I guess it's an exclusion or exception, isn't it?
I think,
Because it's not going to apply then if you're outside the scope of employment.
I think
right?
as Your Honor pointed out, she was in the scope of employment here, and the department certified as much in the papers in district court where this case was removed. I think if she weren't in the scope of employment, it would be a question about the propriety of that certification under the Westfall Act, and then whether it was properly removed and whether the United States was properly substituted.
But it's the Westfall
that's
Act
where it comes
that
out.
gives them the immunity, right?
That's right, Your Honor.
So
They
that's
work
the
together
one
with
you want to find she's not in the scope of employment, then you can bring the state action if she's not.
It's part of the certification procedure under
I
the
got
Westfall Act before the FTCA kicks in, and now that we're in federal
But to
court.
challenge that, they would have had to appeal the certification.
They would have had to challenge the certification at some point in district court or magistrate court, that's right,
I
Your
see,
Honor, but
I
that's not at issue here, and so I think, like you said, under South Carolina law, she probably was acting within the scope of her employment. In fact, that's what the department certified, that she was acting within the scope, so that's not at issue. It wasn't an issue in district court.
So she has no remedy.
She has no remedy under the Federal Tort Claims Act, Your
She
Honor.
had no remedy civil that anybody can think of. Maybe a criminal action could be brought, but no civil action. Can you plausibly tell me any civil action she could bring under these facts?
Your Honor, I don't have a civil cause of action at hand because we're just looking at the claims that she's
There's
brought
none.
in her complaint.
There's none.
and-
You can't bring it in state because of the Westfall Act, and you can't bring it in federal court because the Federal Tort Claims Act is the waiver of sovereign immunity, and that does not apply. There's none.
That's right, Your Honor, that there's nothing under the Federal Tort Claims Act, and we as the
None,
government
period.
are just looking at.
Federal Tort Claims Act anywhere else in the universe except unless you can figure out Bivens, but that doesn't apply. I'm not being argumentative. I'm just getting to the point that these are horrible cases. Something is wrong in terms of how this statute is set up. I can't possibly believe it was meant that a postal worker could come out and violently assault a customer under these facts, and that customer has no remedy civilly. Now, criminally, you could have the district attorney could do it for the state, or the U.S. attorney could do it, and none of that's happening, which sounds, it must be something else for it not to have happened, because it's a horrible set of facts, at least what's presented to us.
As presented to you, Your Honor, that's
Yeah.
right. These are the allegations in the complaint, and they haven't been tested or proven.
Right.
And so the United States would presumably present its version of the facts if this case were to proceed past the pleading stage. But the Federal Tort Claims Act,
I
as
wasn't talking
Congress
about the
wrote
pleading
it.
stage. I don't think it's gonna proceed here civilly
That's
past the
right.
pleading stage. I'm talking about the criminal side of it. That must not be enough there for them to bring an action, or some reason they won't bring a criminal complaint against this individual here. Now, I'm not talking about this case, but you see what I'm saying? That there's no remedy for it, and maybe the only remedy then could be, if you went criminal, she might could get restitution of some sort. But that's a whole different thing. I'm just trying to figure this out. He makes the argument, there's no remedy. Well, maybe the criminal remedy is the only one that's there, but it's not happening, which is outside of this. But from your perspective, everything I'm hearing, I think you're spot on.
I think it's, for what it's worth, I think these allegations fall within the heartland of the intentional tort exception, the enumerated tort exception, as Your Honor outlined, and Congress wrote that exception, and the first few words of that exception carve out any allegations arising out of assault or battery. So as Your Honor pointed out, these claims fall squarely within that exception. I can't speak to the criminal side of things because I don't know sort of the judgments that the local prosecutors and sheriff's offices made here, but it's true that these allegations are sort of squarely within the scope of the enumerated torts exception, both as to both defendants and as to the United States. I'm happy to answer any other questions this court has on those issues. I'll make a couple of just quick points. as I think Your Honors recognized, there weren't any arguments with the law enforcement proviso raised in district court before the magistrate court or the district court. I'm not sure whether that would apply here to these particular employees. The arguments about Medina were similarly not raised before the district court, and any objections to the magistrate judge's report and recommendation. Same with sort of the Martin arguments, which haven't been raised in this court either. And then as to the Sheridan arguments, I think what's important here is sort of the district court recognized that there's no independent duty that's the plaintiff has identified, that's sort of independent of the United States' relationship as an employer with these particular employees. All of the specific provisions that have been outlined only govern the employer-employee relationship, and even Sheridan, both in the Supreme Court and in this court's cases on remand, decision on remand, recognize that any sort of duties like that are properly excluded within the enumerated torts exception, and so there's no relief via that very narrow exception as well.
But counsel, what if the facts, were played this way in terms of, so it's not a hypothetical, it really is just sort of somewhat of a counterfactual in terms of what's played, that the same thing that happened, but instead the suit was for the humiliation that the plaintiff suffered, and by the mere shock, shock in the conscience that you'd be in a post office and someone just would open the door and have this person in a rage coming toward you, and you sue just for the mental anguish that occurred. As a matter of fact, you had, a post-stress type trauma from it. Would that be a case that you could bring? Otherwise, forget about the pummeling and the hitting and that part, the battery part. What this case would be is not arising from a battery or assault, but arising from the letting this person out, knowing that person's rage before they let them out, and and I think the word was, they played, confront her. And in that confrontation, she comes raging at her. And even to the point maybe she didn't even hit her later, but she did. But the suit is for that trauma itself. Because you can imagine, it's like if I, came towards you and said, I'm going to beat you up, and I don't, that's traumatic. And it's hurtful, and the things that people go a long time. Would that be an action you could be bringing into tort claim?
Your Honor, I think it would depend on sort of the way that the Federal Tort Claims Act looks at these kinds of claims is sort of what is by looking at the tort claim, not the damages that are sought. So if they're seeking damages for mental anguish, that wouldn't be the analysis. It would be, is this really a claim for battery of some kind, libel, slander, misrepresentation?
How is the government going to make a person's claim? You can't just say, well, no, you got to go all the way to the end. No, this is my claim right here. What happened to me in that trauma from merchant letting that person out and confronting me in a manner that shocks the conscience, and it's trauma to me. What you say, the government can make you say, oh, no, you got to plead this whole thing out. You can't have it both ways. It arises out of, and even when it doesn't rise out of the battery, you're going to make it rise because it's got to go to that end. So something's wrong with that, isn't it?
No, you're right, Your Honor. If it were a claim that doesn't arise out of assault, battery, or any of the
It doesn't.
torts-
The claim is that it arises from her putting her out there. The battery hasn't occurred.
Your Honor, if it were a claim that didn't arise out of those particular torts enumerated in the exception, that would be different. It wouldn't be covered by the exception. But I think if a plaintiff is attempting to reframe a claim that is actually an assault or battery claim as a negligent failure to prevent that assault or battery, that's exactly the kind of claim that would be covered by the exception. And that's what this court has said in cases like Talbert and Billups and Popovich, and plaintiff here has said, look, we were trying to plead away from the intentional torts exception, and that's not allowed. But if it's a claim that doesn't result in or arise out of any sort of assault, battery, false imprisonment, all of these torts that are enumerated in 2680H, that would be a different kind of claim, but that's not what we have here.
It's interesting. If less had happened to her, she'd had a better claim.
It would be a different
That's what
case,
you
Your
just
Honor,
said.
that's right.
It makes no sense.
It's how Congress wrote the statute.
Oh,
and-
yeah, I guess I understand.
But why wouldn't this be, or could it be construed as a negligence claim? And because wouldn't the United States Post Office have a duty to the individuals coming into the post office as invitees?
The plaintiff hasn't identified any such duty on the part of the Postal Service, sort of as invitees or otherwise. If plaintiff had identified some sort of common law duty that extends to a federal government agency like that in a different case, that might be the case. But here, the district court and the magistrate court went through the specific sources of duties that plaintiff alleged, which were just the single regulation and the 2 employment manuals, and said none of these things give rise to this sort of independent duty that that would support a negligence claim under South Carolina law. And South Carolina law is pretty clear that a public duty on the part of the public government or any authority is only owed to individuals in very limited circumstances, and that's sort of laid out in the magistrate judge's decision discussing Arthur's and other cases of South Carolina law. And so because the way that law works, sort of briefly, is that there's only a duty on the part of the public entity if the statute, regulation, or provision at issue lays out a very specific kind of harm that the public entity is supposed to guard against, a specific class of plaintiffs.
There is something here that could have been, might be, I don't know. But both of these individuals, Mr. Merchant and Peppers, had a history. Peppers himself, Peppers the Merchant, had a history. He was actually transferred here to be postmaster because of some misconduct somewhere else, not directly this kind of thing. But she had a history of it, and the post office hired them. And if you could show that they were negligent in the hiring of them, that might be covered. Do you not agree? Because if you hire someone you know to be violent, and as a result of hiring them, that person does just what you know or should know they would do, assault someone. It's not the assault that's the problem with the situation, it's the hiring of them. You can't hire someone who is a bully or someone who assaults, and then when they commit it, says, oh no, they committed assault, I don't owe you anything. When you don't go back and look at the basis upon which they were hired, if that's what's being challenged, not the assault itself. Now, that's a consequence of it, so because you want damages from it that comes down, but foreseeability and other things come out into play, but at least the initial part of it of getting in the court, where Judge Gregory is going, if you want to create an opportunity, it's not just called that assault negligence, but to focus on how those 2 individuals got there, and that they were individuals who it was foreseeable that they would commit violent acts, and they did. Would that not be, if that was played in that way, would that not be satisfactory at least to get beyond the initial pleading stage?
No, Your Honor. I mean, negligent hiring, supervision, and retention are all claims that this court has correctly recognized are barred by the discretionary function exception. That's what this court held in Souter in the footnote 6. It's what it reiterated in LaRose. That's right. And that's consistent with the case law of other circuits. In Souter, the court quotes the DC Circuit and explains why those kinds of claims are properly barred by the discretionary function exception. And then Judge Gregory's opinion in LaRose explains why that's the law of the circuit. And so I think, no, those claims would be separately barred by the discretionary function exception.
What about the negligence of opening the door and allowing this known violent employee to go out into the area where the members of the public were standing?
Your Honor, the way this court has explained this jurisprudence is that any sort of claim that there's a sort of negligent failure to prevent an assault or battery, which is similar to what Your Honor is describing. In fact, I think what Your Honor is describing is also precluded by the enumerated torts exception. That's consistent with what this court has said in Tauber and then the cases that follow it, Billups and Popovich, that these are just ways of escaping 2680H's reach, and they're also barred by the scope of that exception. That's, again, sort of within the heartland of the exception. And there's this complaint in particular actually doesn't even allege that the negligence. It sort of says that Merchant knew or should have known that this was going to happen. The United States went beyond mere negligence, that the Postal Service knew or should have known that these actions are going to occur. So all of the allegations here are actually alleging all sorts of intentional tortious conduct as well. So I think, fortunately or unfortunately, these claims are all sort of squarely precluded by the enumerated torts exception and then by the discretionary function exception to the extent they bear on hiring and supervision and other sorts of negligence claims in that vein. If this court doesn't have further questions, we'd ask it to affirm the district court. Thank you.
Thank you, counsel. Mr. Hawkins, you have some time reserved.
Thank you, Your Honors. I would respond briefly to just a couple of points. One, the duties, we were, I think, and the reason that I think we were very thorough in pleading of our duties and that sort of thing is that we litigate these kinds of cases and try them in state court a lot. And so the duties are usually owed one or more of the following duties, and then we give a grocery list. So to argue that there's no duty described or that there's no duty that was pled, I don't think that's correct. And in addition to that, the public duty rule doesn't bar stuff like this. If it did, you could never have a gross negligence claim in state court. The public duty rule, it does not bar the claim before this court because there's a special relationship between the tortfeasors and the victim. There's an undertaking of a duty both before and after the actual assault occurred or whatever it was. And so I think the duties are sufficiently pled, and also saying knew or should have known, that's not pleading an intentional act. You know, we litigate 1983 cases. We all the time have to plead and prove something that's more than mere negligence, but not quite intentional. And so something can be, a product of something that somebody didn't do that they should have done, or they knew they should have done, or should have known they should have done, doesn't make it an intentional act. And what we're up against is sort of the government says heads we win and tails you lose. Once she puts that shirt on, she can do whatever she wants to anybody she wants as long as it's on the post office floor. Or once there's a battery in the mix, it kills everything else that happened. To Judge Berner.
That's true.
Well,
That's the way Congress wrote it. I'm with you on it. But what you just said is probably true.
But
once she puts gets up there in that post office, that government employee, you got the Federal Tort Claims Act,
Right.
You can't get there, and the Westfall Act's not gonna let you go to state court, which leaves you with criminal charges. You can be liable for criminal acts now. They don't shield for that. But I don't understand why the district attorney or the district attorney wouldn't prosecute it, except they prosecute cases they think they can win. So I don't know. That's why I won't make a decision. I won't comment
Right.
in terms of why they didn't do it. I'm just saying, there is the conundrum there.
Well, the answer I got on that was, this is not in the record, but the answer I got on that was, well, it was COVID. We couldn't really do anything. And this place, Your Honors, I'm very familiar with it. I grew up
Okay,
near
well, you
there.
have the record you have, but I'm looking here at Sheridan, and the Supreme Court is talking about the Tort Claims Act not applying when there's a voluntary undertaking to provide care to a person who's visibly drunk and visibly armed. And so is this your argument with regard to the failure to care for her your client once she was injured?
Well, my argument as it relates to Sheridan, Judge Berner, would be that what Sheridan says is basically the source of the injury doesn't matter at some point. If she were in there and a chandelier fell on her head and he walked out and did the same thing, there would be liability. The interaction had already stopped. His interaction with her at that point doesn't spring from a battery. It springs from breaches of his duties when he goes out and says, I'm not going to call anybody, and you can't call anybody, and does this in front of people. And so if we look at Sheridan in that context, and where the Supreme Court said where there may be a duty independent of what happened, it doesn't matter if it was because the government actor took control of a dangerous animal that hurt someone or an explosive device. They still have their independent duties. So in that context, it would be, okay, maybe, if she did have the mental state for battery, and if she's not in the proviso, and they say she's out of the suit, you don't have a remedy against her, we could still have a remedy against Merchant from his actions before and after the battery. Because otherwise, the law is, well, once a battery happens, it absolves everybody of liability. And that can't be what Congress intended. I mean, they waived sovereign immunity for a reason, and then they came back and tried to fix more of it in 1974 when they added the proviso. The old Dale Height case looked at this, and the dissent said, well, there's a discretionary function, so we're barring it, and the dissent said, look, if we don't fix this, then it's not the king can do no wrong, it's just the king can do only small wrongs. And Congress had to come in and make a specific remedy. in that context. And so what we're asking the court to do is to look to the language of Bivens. And I know Bivens is a really up skyscraper battle at this point. But look at the language of Bivens where the Supreme Court repeatedly says in those 3 cases and in the 12 cases since, all the way up to Egbert, if there's not another remedy at law, we should find one. That's American jurisprudence, and that's the common law from which it sprang. So that's our argument, Your Honors.
Thank you, counsel.
Thank you.
Thank you both for your arguments. We're going to ask that the clerk adjourn the court until tomorrow morning, and then we'll come down and greet counsel.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.